Your Honor, the defendant, as we discussed in chambers, continues to test positive. It appears she needs a higher level of care. We are requesting, through the coach, that she be placed in residential treatment. We also will request $250 in laboratory fees. That would be to the Franklin Police Department. There's also a weapon involved. We would ask that be forfeited and destroyed.
Officer Torek, what's the recommendation of probation?
Your Honor, probation does think that Mrs. Poole is amenable to community control. Her positive drug test at the coach earlier this month.
Wait, hold on, Officer Torek. Why do you keep shaking your head, Miss Poole?
Because I'm clean.
No, you are not clean.
Sir, I'm doing the programs. I'm meeting with my counselor. I don't know what's going on. I don't know if it's the medicine I've been taking for my seizures. I don't know what it is, but I swear to you on everything I love, I'm not doing anything. I wouldn't do it again. I don't want to. I've got 2 jobs. I'm keeping busy and keeping occupied with other things. I don't know what happened. I really don't.
I'm sorry, go ahead, Officer Torek.
I was informed that she did have a positive confirmed test at the coach on the 10th of this month. She tested positive again today. The recommendation from treatment at the time of her assessment was for outpatient. However, considering the positive test that was confirmed by the coach on the 10th and the 21st, which is being today prior to court, there is a recommendation that there should be at least an increased level of care. That being said, no other recommendations other than entering and completing treatment and remaining compliant while on supervision.
Are we sending today's test out?
Yes.
And we don't have the results of the oral swab?
Not yet, Your Honor.
Because Officer Conroy, your position is she's not even close to being clean, right?
That's my position. When I tested her this morning, her sample was bright green, which is a sign to us that she was possibly using something to alter the test or flush her system.
I have a kidney infection. I'm on antibiotics. I only have 1 kidney. I've passed every other drug test. I honestly don't understand what's going on.
Here's where we're at, Ms. Poole. The recommendation of Officer Torek's pretty good recommendation to send you to residential treatment. That seems like the way to go, but I'm not going to do that. I'm going to send you to prison.
Please don't.
I am, because you will, if you don't acknowledge that you are not clean, then there's nothing I can do. But I am going to wait until we get confirmed positive tests. I want to know for sure, 100%. So I'm going to take Ms. Poole into custody today. We're going to reset this for sentencing in a couple of weeks when we have the results.
Please don't, sir. Please. Please, I swear.
Not doing anything today, Ms. Poole, but we're going to know when we get those oral. We'll get the oral swab back from last week, and we'll get the drug test. We'll send one out from today. Then we'll know if you are clean or if you are not being honest. So, Mr. Madden, we're going to continue this out a couple of weeks and get a sentencing date with Ms. Idle.
I do that. Thank you.
All right, that's all.
Oh, God.
Email me as soon as we get results.
Put you up on Zoom.
I'm gonna go get your tablet.
Capital One versus Marcia Tong, 2505254.
Good morning, Your Honor. Dylan Clark, P 88474, here on behalf of plaintiff.
Good morning. And I also have capital. Oh, I see.
Yeah. I'm sorry,
Okay.
Gary, I'm trying to figure out how to unmute my phone. I apologize.
It's all right. Your appearance?
Gary Epps, P046306, subbing for Jeff Horowitz on behalf of Marcia Tong.
I think I'm gonna need some more, but I got a couple right here. Okay. Any resolution on this, gentlemen?
Your Honor, I didn't have a chance to speak to opposing counsel yet. However, if Gary isn't against doing so, 60 days discovery and a scheduling order would be great.
Yeah, sir, I have no settlement authority beyond what might have already been conveyed to Dylan, so that would be fine with me.
All right, let's do this. Today is the 21st. Just give me 1 second, please. All right, I'll give you until we'll call it May 21 for June 21 for discovery. No motions will be heard on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. There will be no ADR. Nobody demanded a jury, correct?
Correct, sir.
No settlement conference. I'm putting down 1/2 hour. Witness lists are due by May the 21st. You do not have to file a trial brief. If you choose to file one, it has to be filed and exchanged not later than 7 days before the trial. I will, that's it. We're going to give you the trial date right now, Jennifer. You have one for me, say in
Absolutely.
latter part of July, early August.
July 27th at 10:30.
July 27th at 10:30, okay?
Very good. Thank you, Your
Looks
Honor.
like
Anything?
I'm back here at 10 o'clock too, so thank you, everybody.
Okay, thanks, Mr. Apps. Anything else, Mr. Clark?
Nothing further in this matter, Your Honor. I was speaking to a defendant in the breakout room for Capital One v. Barry. We are ready for that. We have a resolution.
You have a resolution?
We do, yes. I believe that she is in the breakout room still, though.
I see her right there.
No,
Jen-
there she is.
Here, I'm gonna just hand you these, Sadie. Capital One versus Tina Berry, 2600065. Your name, ma'am?
Tina Berry.
Counsel?
Dylan Clark, P 88474, here on behalf of plaintiff.
All right, so you said you have a resolution. What are the terms?
Your Honor, Ms. Berry has agreed to make monthly payments of $124 towards a total judgment amount of $2,973.66.
Get a little closer to that device or turn it up, will you please? 2973, she's gonna pay 124 per month.
Yes, $2,973.66, Your Honor. That consists of damages in the amount of $2,848.31 and court costs in the amount of $125.35. First date of payment will be May 1st, 2026, continuing on the first of each month thereafter until the balance is paid in full. And Ms. Berry has provided me her email address so I can forward her the consent judgment along with payment instructions for her review.
Ma'am, do you understand everything that Mr. Clark just said?
Yes.
So he's telling me you guys are, and this is going to be in the form of a consent judgment, correct, Mr. Clark?
Correct, Your Honor.
So ma'am, do you understand if you consent to this, there would be a judgment entered in favor of the plaintiff, Capital One, against yourself. It would call for damages in the amount of $2,973.66 with a further provision that you have to pay $124 per month beginning May the 1st of 26 and the first of every month thereafter until paid in full. Do you understand that?
Yes, I do.
And do you agree to that?
Yes.
And so long as you do that, the plaintiff cannot garnish wages. They could still garnish bank accounts. They could garnish tax returns, but no wages. Do you understand that?
Yes.
Can we short circuit this? And we could, if you want, you care to just give Mr. Clark your permission to sign your name to the proposed consent judgment?
Yeah, he can do that.
I mean, sometimes it just seems easier if it's clear, it's on the record. If he added something and he wouldn't do that, he's an officer of the court that you didn't like, then you could say, hey, that wasn't part of the agreement. Do you understand that?
Yeah, I do.
All right. So he has your permission to sign your name to the proposed consent judgment?
Yes.
Okay. You are all set. I wish you well. Thank you both. Have a good day.
Thank you.
Thank you. You too.
Velocity Investments versus Jeffrey Dillon, 2600385.
Good morning, Your Honor. Angelina Abufarha, P number 88197 on behalf of plaintiff.
Okay. Is the defendant here?
Yes, I'm here.
Okay. I'm sorry. Mr. Dillon, your name?
Jeffrey Dillon.
All right. Just give me 1 second, please. Any resolution on this one, counsel?
Not yet, Your Honor. We did enter settlement negotiations, so we could have a potential resolution shortly.
Okay. And your P number is 88197, right?
Correct, yes.
All right. So you guys just want dates? Do you need discovery?
Dates are great. You can open discovery just in case. I know plaintiff, we don't really send out discovery, but in case a defendant would like to.
June 21, you have to conduct discovery by. Discovery is the exchange of information, Mr. Dillon. So if you wanted something, documents or what have you, or you wanted to send them interrogatories, you have the right to do that. You have to file a witness list in this case by May the 21 of 26. Witness list due June the 21 of 26. You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. No motions will be heard on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. Still July 27th at, would you say 10:30, Jen?
Yes, Your Honor.
So I'll set the trial date for July 27th at 10:30. You should have this very shortly. You have to bring up anything else, Ms. Abufarah?
No, Your Honor. Thank you.
All right. Mr. Dillon, anything else?
No, sir.
Have a great day, you two. Thank you very much.
Thank you as well.
Do I have anything else down there?
Judge, I do have Miss Brown back in. I'm not sure if Mr.
Is that
Patel is going
Midland
to come back
versus
into.
Patel?
Yeah, I'm not sure if he's going to come back. There he is. He's back in the courtroom now.
All right. Midland Credit versus J. Patel, 2505019. Everybody's name, please.
Adrian Brown, PA 3947 on behalf of Midland.
All right. Any resolution?
We have a resolution, Your Honor. We have come up with a consent judgment. We have damages totaled at $2,905.53 to be paid $300 per month starting May 15th until the balance is satisfied. And Mr. Patel would prefer for me to send a copy for his review for him to sign, and then I can submit it to the court once it's returned to me.
You understand and agree to those terms, Mr. Patel?
Yes, I did.
So you are agreeing by this that the amount of $2,905.53 is owed, and you agree to pay $300 per month beginning May the 15th of 26.
Yes.
All right. So I'm going to go ahead and wait for the judgment. Jennifer, we're going to reset the pretrial in case I don't have it by then. So we'll reset the pretrial for May the
18th?
No, before the 15th, I want to do it. So let's set it for May the 12th or thereabouts.
We can do May 11th. It's your probation day, but it would be one simple pretrial. So
At
we can do
8:30.
that at 8:30.
So we'll reset the pretrial. Assuming I get everything, you have to show up unless you get the judgment back signed by me before then, Mr. Patel, okay?
Can you explain that again?
Yeah, because I need to have, there has to be a control date. She's going to send it to you.
Okay. Is that the signature that she's gonna, I have to sign?
Correct.
Okay.
And you're going to send it back.
Mhm.
And I can't just let this case sit out there because sometimes people don't do that. So I'm going to reschedule this for May the 11th at 8:30.
Okay.
If you don't have to show up, so long as you forwarded the proposed judgment to her, she sent it to me and I've signed it and you have a copy. So they'll send you a copy once I've signed it down the hall. Okay?
No problem, sir.
All right. You understand?
Mhm.
Okay. You're all set. Thank you.
Thank you.
Thanks,
you, Your
Ms.
Honor.
Brown. Do you have any others or not?
I believe that's all. Thank you so much.
Have a great day. Thank you.
You take care.
All right. What do I have now here? Is it LVNV versus Hancock?
Judge, I don't have defense attorney there, but plaintiff's counsel's in the breakout room. I have the 9 o'clock Velocity versus Shelly is ready. Both parties have spoken.
You have that one. Okay. Thank you. Velocity versus Velocity Investments LLC versus Kelly R. Shelley, 2600675.
Good morning, Your Honor. Michael Bengstein, P69778 on behalf of Velocity Investments.
Ma'am, your name?
Shelly.
Have you two talked?
We have, Your Honor. We've exchanged phone numbers and email addresses. We did talk about payment arrangement or settlement, but we don't have a deal at this time, Your Honor. We need to put some dates on the calendar.
69778. Let's see, ma'am. I'm going to go ahead and ask you. All right. First of all, I'll be glad to give you guys discovery. Discovery cutoff is June 21st. No motions will be heard on the date of trial. All motions have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury trial, correct?
That's correct, Your Honor.
And you didn't either, correct, ma'am?
No, Your Honor.
All right. So witness lists are due May 21. Discovery cutoff, which is the exchange of information, ma'am. If you want something from them that you think will help you defend the case, then you're free to request it in writing from them. You're free to send them interrogatories. Witness list due May 21, discovery cutoff June 21. Pleadings are in order. And your trial date again will be July the 27th, and that will be at 10:30 in the morning. July 27th at 10:30 in the morning. Okay? Is there anything else anybody needs to bring up here?
No, Your Honor. It sounds like 7/27 at 10:30 a.m. bench trial, June 21st discovery cutoff, May 21st witness list and exhibit list. All motions now filed and heard no later than 20 days before trial, Your Honor.
Correct.
Okay. Thank you, Your Honor. I don't have anything further.
All right, you guys are all set. Have a great day. Any questions from you, Ms. Shelley?
No, Your Honor. Thank you.
Thank you very much. LVNV versus Brian Hancock, 2600624.
Your Honor, Mr. Strauss just checked in and he's in with counsel on that one.
Yep, another.
The two cases.
Acceptance versus
they're
Amy
they're
Tank.
coming out now.
Is Amy Tank out there?
She is not yet.
LVNV versus Brian Hancock, 2600624.
Good morning, Your Honor. Oh, I'm sorry. Good morning, Your Honor. Frank Price, PA 2598 on behalf of plaintiff.
And Gary Strauss on behalf of defendant, 48673.
All right, just give me 1 second.
Sure.
82598, right, counsel?
That is correct.
All right, good enough. No resolution?
No resolution at this time. If we could just ask for 60 days of discovery and we will continue settlement negotiations.
No motions will be heard on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. Discovery cutoff will be June 21. Witness lists are due May the 21. You don't have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. July 27 will be the settlement conference. I'm sorry, the bench trial date, and that will be at 10:30 in the morning. Okay.
All right, sounds good.
Anything else anybody needs to bring up?
Nothing. For
No.
All right. Have a great day, gentlemen. Thank you very much.
Thank you.
I have a couple more with you. Actually, yeah, several more, but two more in the 9 o'clock.
Which one's that?
One might be on the off the docket already. Barbara Johnson, 00150. We had a consent judgment filed Friday.
That we did get that consent already, Judge,
Okay.
so that one is off.
And then the other one is JP Morgan versus Ned 2600662, Attorney Cruz and I.
Do you have JP Morgan? Do you have those?
I gave them to you.
Do you have any more?
I gave you that left it up.
Oh, wait a minute.
Yeah.
JP Morgan, my apologies. JP Morgan Chase versus Tiffany Ned, 2600662. Okay, appearances.
Good morning again, Your Honor. It's Frank Price, and that's P82598 on behalf of plaintiff.
And for the defendant, Trevor Cruz, P73401.
Guys, just give me 1 second here, okay?
All right.
Okay, so I have 82598. How high are the P numbers? Is anybody at 90 yet?
I don't know if I've seen a 9 yet.
Yeah, I can't say that I have. Probably getting close, though.
73. Yeah, I know. It's crazy. June 21 is discovery. So no resolution, right?
Yeah, not at this time.
That's fine. All right, so here's what I'm going to do. Witness lists are due on May the 21st of 26. Witness lists due May 21 of 26. Nobody demanded a jury, correct?
Correct.
All right, so we're not going to have a settlement conference. I'm putting down 1/2 hour for trial. Discovery cutoff June 21, no ADR, none of this. And then I'm going to simply set the trial date for July the 27th, at 10:30 in the morning. And again, all motions for summary have to be filed and heard not later than 20 days before the trial. Okay. I think that covers it unless somebody has something else.
No, sounds good. Nothing planned.
Nothing for
Pardon?
defendant.
Okay. Thank you very much. Have a great day, gentlemen. Thank you.
Back at 10, actually. Have a good one.
Credit acceptance versus Amy Tank. Credit acceptance versus Amy Tank. 2504669.
Judge, if I may, I've got someone that just logged in on an iPhone. If I can get their name, please, if they unmute.
Phone, we need your name, please. Can you tell us who you are?
Good morning, Your Honor. My name is Cortina Thomas. Sorry.
Okay, you have to start your video and put your name on there, would you please? So we
Judge,
know
I'll
who
add
you
her
are.
name.
Okay.
Thank you.
All right. So is anybody here on credit acceptance versus Tank?
The plaintiff's attorney is. I'm letting him in now. But defendant has not checked in yet.
Really? Well, there's longer than moments. Most of them will be.
Mr. Baig, I'm ready to go, but I gotta wait 15 minutes. So I'm gonna give them till 15 after. If they're not here, I'll call it and I'll default, okay?
In the meantime, I'm going to put Mr. Bagg in with Miss Thomas. He's on that case.
Okay, that's fine. John, give me everything else, will you please? Okay. People against Jamie Antonia Williams Bay, 23W831-736. Come on up to the podium.
Right to the podium. Good morning, Your Honor. Mr. Shem, comparing if my client just needs to my meeting, right? You say change correct, sir? Is anyone in the back?
Give me 1 second. I'm curious as to what prompted her or him to come in here. Or
It's
to come in.
I misspoke, Judge. It's to late.
Right. What prompted her to come in today?
Your Honor, she had
I remember this one. You know what? That's pretty amazing, isn't it?
I said I already told him. I already know about the get started.
Get a scolding. You haven't been here in 3 years. If you call that a scolding, I call it disrespectful for you not to show up. But I remember this case, and that's never a good sign. 3 years later, I remember this case because your attitude was, and now you've seen the light. Where's she been for 3 years?
Your Honor, she is now gainfully employed in college. She had a period of time where she did not have any lodging, and she's gone through an ordeal, but it does appear that she's made some positive strides. And she's not arrested on a new charge or anything. In fact, she called the police for assistance, and it was at that time they discovered that there was not a standing warrant, but she's not getting picked up on a new case.
Is Heather here, Jennifer Wiseman?
Yes, she is, but I can pull something up if you need me to.
Yeah, pull this case up.
Go ahead.
I
Do you have
sensed
the case number by chance? I can.
23W 831 736.
Thank you.
So I sentenced her, it looks like, back on June 21 of 23. I set a review hearing. Well, then she failed to appear on October 2nd. It must have been a show cause. It was a show cause. So let me find that show cause and we can go from there. I don't know. Okay. The charge is failure to pay fines and costs as ordered. This is part of a show cause dated September 18 of 23. So have you had a chance to look at that with her or talk to her about that?
No, Your Honor, I saw that there was an outstanding fine, I believe, and that there was just a apply with all terms and conditions. I'm more concerned with the amount of time that's elapsed since the last show cause.
So I'm going to arraign her on that. And then I'm going to go from there, okay? Ma'am, you're charged with failure to pay fines and costs as ordered. This is part of a show cause dated September 18 of 23. And you didn't show up. That's your first technical violation. However, now you've absconded. So that means that your height of status could be revoked. I don't believe I ever revoked that status. The conviction entered. And you would be subject to a 90-day jail term. Do you understand?
Yes, sir.
You are presumed innocent. They have to prove you guilty by a preponderance of evidence on this, since it's a probation violation. You have the right to a hearing. At that hearing, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, at any time, you'll be giving up all those rights, and we're not going to have a hearing or a trial of any kind. You understand that?
Sir.
All right. You understand at a hearing, you could testify or remain silent. If you remain silent, that silence would not be held against you, and you'll have the right to cross-examine any probation witnesses. I can't hear you.
Yes, sir.
All right. So in a second, I'm going to ask you how you wish to plead. Is she going to plead guilty or?
Yes, Your Honor, in these circumstances, it's a black and white situation. She knows that she did not make a payment, and she knows that she failed to appear. I don't believe that the hearing would be necessary that, but we will be wanting to provide an explanation. But yes, in the circumstance, we're not contesting those two scenarios.
John Colin, Beth, to the charge that you failed to pay fines and costs totaling $935. How do you wish to plead?
Guilty.
Did you fail to pay?
Yes. Yes.
I can't hear you.
Yes, sir.
Anybody force you to plead guilty?
I'm just ready to pay. I'm just trying to get this.
Plea is accepted to that charge. I find it to be an accurate plea made voluntarily and understandingly. Here's my concern with you. I bet you didn't do the community service either. And I bet you didn't do the positive strategies program either.
Definitely did the community service and a positive strategy.
Let me
And I sent her emails, and that's why I had tried to contact her.
just keep your voice up.
I just tried to contact her on email and just let her know like I couldn't make it. So I was just trying to, let y'all know so y'all can another date or just so I can get here. And I couldn't, and it's like everything just fell apart and I couldn't even get here. So
You couldn't get here.
it really was after the fact, and I couldn't get up here and with everything else going on with my life, honestly.
Well, you got here to the Speedway on Allen Road in Woodhaven, and Allen Road's right next to us.
Yeah,
That's when you committed the crime back in February of 23. And then I heard all this from your lawyer and you about how your employer, right? Correct me. These were lottery tickets. Yes?
Yes, but I'm not gonna lie. I feel like honestly, I feel like they threw me under the bus. I wanted to take that to trial. I didn't know how and what to do. And honestly, I was scared. So
You were what?
I feel like they threw me under the bus because it wasn't me doing it. It wasn't me doing it. So and they wasn't giving y'all no cameras or footage, anything, and I didn't know how to go about it. And no knowledge, none of that. So of course I was angry. I was scared. I didn't know what to say.
I wouldn't have taken your plea if you didn't admit that you, Ms. Murphy was representing her. I remember this vividly. And she was saying that at least initially that the employer asked her to steal, her boss asked her to steal the lottery tickets. That's what I was told. I'd love.
We're here on the issue of competency. Justin, I forgot that report. Give me 1 second. Oh, I'm sorry.
We switched on you, Judge. That's okay.
What happened to Ms. Nicholson?
She had a meeting that she couldn't miss, so she asked me to come down and.
Oh, well, I'm sorry. I didn't even look up.
That's no problem, Judge.
Yeah, you're not Ms. Nicholson. Yeah. Oh. Sorry about that. I did have it. All right, we are here on the issue of competency. The court has received a report from Dr. Rose from Summit. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor.
Do we have a stipulation to the report?
Yes, Your Honor.
All right,
Yes,
at
Your
this
Honor.
time, then the court's going to find that the defendant is competent to stand trial, and that will be, report will be admitted as the court's exhibit. Mr. Goodyear, what are we doing beyond that?
Yes, my understanding, the defendant will enter a plea of guilty as charged to count 1 in the indictment, trespass into habitation. In exchange for that plea, the state will dismiss count 2.
Ms. Kirby, is that accurate?
That's my understanding, Your Honor. Ms. Fields has reviewed the plea form, and I believe she understands what she is pleading guilty to.
Okay, Ms. Fields, you're telling me you're going to change your plea to count 1 of the indictment. Before we get to change your plea, I am required to go over some things with you, okay?
Okay.
How old are you?
35.
How far did you go in school?
I dropped out in 12th grade.
Are you able to read and write?
Yes.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case? Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Ms. Kirby?
Yes, ma'am. Sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document. This document is called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with Ms. Kirby?
Yes, sir.
You feel comfortable that you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to 1 count of trespass in a habitation. As a felony of the 4th degree, that carries a maximum penalty of 18 months in prison and a maximum fine of $2,500. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
Now, you're also subject to a discretionary period of post-release control, which means that if you are sent to prison when you are released, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison. The court does have discretion to place you into community control, what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've gone over?
Yes.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes, sir.
Mr. Goodyear, could you read a statement of facts?
Yes, Your Honor. Your Honor, by the 6th day of December 2025, Warren County, State of Ohio, the defendant Ashley Fields did by force, stealth, or deception trespass in a permanent or temporary habitation of any person when any person other than an accomplice of the offender was present or likely to be present, excuse me, in violation of section 291112B Ohio Revised Code.
Ms. Kirby, anything on those facts?
Nothing on the facts, Your Honor.
Ms. Fields, did you hear the statement that was read?
Yes, sir.
Do you admit and acknowledge that what he said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed.
Yes, sir.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty. And based upon the statement of facts in your plea, the court will make a finding of guilty. I am going to order a pre-sentence investigation, Ms. Fields. Quite frankly, I don't know enough about you or your history to sentence you today. So I'm going to order that, and we'll come back in a few weeks and do sentencing at that time. Mr. Goodyear, is there anything else?
Judge, nothing else other than we'd ask that she be held in the meantime.
Ms. Kirby, you wish to be heard?
Yes, Your Honor. Thank you. Ms. Fields has been doing some research and has been talking to some people at Summit about some potential mental health facilities that she could be transferred to or engaged in the meantime. One of which is Nova Behavioral Health, and I believe that they have an inpatient component to their facility. We would just ask that Ms. Fields be able to participate in any assessments and see if there is a bed available that she would be able to be transferred to at Nova or any other facility. Ms. Fields is doing extremely well with her mental health, and I think that we can all see that from the last time that we were here in court. She does have an underlying substance abuse issue that she wishes to get professional treatment for. She tells me that she's never had the opportunity to get real inpatient treatment for substance abuse and mental health alike, and would like the opportunity to do that instead of sitting in the county jail. She understands that there would likely be an ankle monitor component to this and is willing to comply with any orders of the court.
I am going to decline that request at this time. I quite, as I said before, quite frankly, Ms. Fields, I don't know enough about you. I'm just kind of reviewing your prior criminal history, which is significant for someone who presents the way that you do. So I'm going to deny that request. I'm going to hold you in the Warren County Jail pending sentencing. All right, that's all.
Thank you, Your Honor.
To go back and listen to this. I mean, I give myself credit for even remembering any aspect of this, given the fact that this all happened 3 years ago, and I've only had probably 8,000 people in front of me since then. I want to know why she didn't show up, and I want to know why she didn't come and ask for time to pay when I told her she could do that.
I really ain't had no. I didn't have nobody. I didn't have nobody. So you feel me to tell me that this is what you got to do. If you don't do it, you definitely gonna go to jail. Just you mean I've been through so much since I haven't been here. So like, I got a lot of knowledge now. I go to school for criminal justice, so I know there's certain things that you have to do, but there's certain things that you feel me that you just gotta.
You're going to school where for criminal justice?
Oakland Community College. Yeah, I'm about to graduate actually.
With an associate's?
So
Do you have proof of that?
it's on my phone. I got everything. I got a FEMA certificate. I got the first year on it. I think.
Your name?
Elizabeth Lost Probation, Your Honor.
Did she do the positive strategies program in the community service?
She did do her community service, Your Honor. She did not attend the Positive Strategies program. She indicated to me that she was struggling financially. I actually worked it out with PRS. They waived a lot of her late fees and courtesy fees, so she could attend that program, but no, she did not end up attending.
Ma'am?
The last communication from PRS was that she wanted to share another update with me. She had to reschedule her session from the night before, waived her fee as courtesy. Unfortunately, she failed to attend the scheduled session again. That is from Kristen at PRS.
Jennifer, give me a new Woodhaven date real quick.
Sure.
Let me just double check something. How much trouble have you been in since you were in front of me? Oh, you went out and got something else. You got a CCW dismissed because it was under HIDA.
Yeah, it was.
You still have warrants. Let me see how many warrants you have here.
I didn't have no CPU.
Here's what you have. Warrant out of the 24th district, warrant out of the 23rd, 23rd, 53rd, 37th, 46, 36, 36, 36. You got about 8 warrants out.
Right now?
They just ran this today.
What? No, I only thought I had the ticket warrants. I'm not even worried. I'm not even what's it called. Like I went on my ID and my driver's license. I literally got to pay 2 no insurance tickets, which I did have insurance. I just
Ma'am,
didn't get.
Let's stick to the issue.
Yes, sir.
Do you work?
Yes. I'm a day on my side. I've been working there for 4 months, going on 4 months. Be there every day. Thursday is the only day I don't be there because I can't work.
Why should I not revoke her HIDA status?
Yeah, I think that, putting it
She didn't
down,
do the positive strategies and she's been blowing us off for 3 years, 2.5 years.
Judge Simpson did indicate that, you'd be seeking, potentially another day in Woodhaven's here. I think that some of the statements that she's made regarding school, could be verified and maybe that put her in a better light for reconsideration.
You have the money now?
I definitely can pay you good. I can go on my mic pay, get you 200, pay 200 today.
Well, you owe us over 900.
Yeah, 935.
No, you owe more than that now. There's warrant fees and everything else. You came here after 3 years and you came here with only $200 and you knew you owed at least 900.
I don't get paid till Friday. Sorry. I don't get paid till Friday. And then I just gave my auntie rent money, so
Give your auntie what?
rent money, so I didn't listen. I got a lot. I still got a lot going on. I want to get this out the way. I'm not gonna lie. I definitely trying to get this out the way. I definitely told him I'm trying to get this settled. You know, because I already know. I knew this was gonna come back to me. I just didn't know it was gonna come back today. And I should have been got it together. And that's just me not having, you feel me? Yesterday was my daddy death day, so it's not like I feel me. Everything just fell apart. When we give up work at 3 in the morning today, like,
I know, but you remember what an attitude you had with me?
yes, and I apologize because I was a kid, didn't know nothing.
Well, you act like you've grown up by 28 years. This was only 2.5 years ago. You were born in 03, right?
Yes, sir.
I'm not amused.
I know it's not like I got any items. I don't got nobody to look up to. I gotta do this.
Where's your mom and dad at?
Dad passed. And my mom, you really don't.
I can't hear you.
Dad passed. Me and my mom were not cool. So
You're not cool? You don't get along?
very.
You're not showing her enough respect.
No, it's not like she give her kids that type of respect. You know how these generation mamas be. Want to do what they want to do. I take care of their kids and treat them and show them the right way.
Here's what I'm gonna do. Jennifer, give me a date when Mr. Urick's on my docket, will you please?
You've got April 29th or May 13th.
Beth,
Yes,
positive strategies program.
yes.
How long until she could get into that?
I honestly, I'd have to look at the website. It's offered, about once every about 4 or 5 weeks. I am honestly gonna go off memory. I wanna say it's being offered like the second Thursday in May, like May 13th, maybe. I don't, I'm
Give me
again,
a later date in May.
The 27th.
And how many days is that program again? It's just,
it starts with the initial.
right, but I didn't order any follow-up, so it should just be one day, right?
Yeah, it should just be one day if no follow-up was
We're
ordered.
gonna set a sentencing for, what'd you say, Jennifer?
May 27th.
At 8:30 in the morning. Now, I'm setting a $200 cash bond. I'm accepting your guilty plea. I'm gonna write down here, defendant 2, attend positive strategies program. Let me tell you something. If you're truly, and bring proof, bring proof.
Bring it out.
Defendant attending criminal justice program at Oakland Community, I'm sorry. Listen to me pardon me?
This is literally my last semester. I'm supposed to graduate on.
Well, I tell you what, you can take a criminal justice degree and pretty much throw it down the garbage if you're convicted of things like this in CCW. Now you got the one off your record. And you better go over and take care of at least a couple of these warrants. So I'm giving you 5 weeks here. To take care of at least a couple standing warrants.
I didn't even know I had it. I don't even know how.
So even though you were wise with me and disrespectful, that's the beauty of the criminal justice system. I'm still going to treat you fairly. You're going to post $200. Jennifer, tell Heather or whoever to print
I
out a
am
note.
relaying it right now.
Thank you very much. May 27th at 8:30. Take care of a couple tickets. Do the do the positive strategies program, and you better come back with all the money here too.
Yeah, I was,
Listen, this is it. I can't extend probation anymore. So you gotta come back with, there's restitution of $300. So you're gonna be able to come back with the other 700 in 4 or 5 weeks?
I'm not gonna lie. I was about to just ask you, like, can I pay it through the 7 weeks? That's what I was
I can't do it.
So you just want me to come on?
You have to.
Yes, sir.
If you want this off your record, you have to.
Yes, sir.
Okay?
So
In fact, if it will help you, just wait 1 second. You're mumbling. Just let me finish, please.
I'm just happy. I'm sorry.
Happy.
But like, I'm just tired. Sorry.
She did this before too. She won't stop talking.
That's my part. That's what I'm in therapy for.
Court will consider not requiring you to take care of other tickets. I mean, you're still gonna have to do it. If D comes with all money. I can't dismiss this for you if I don't have all the money. I can't do it. You had 3 years, 2.5 years to save. That's all I can tell you. Post your bond. Good luck. I wish you well. I hope I can dismiss this for you. Good luck. Thank you.
Thank you, Judge.
Thank you, Judge.
Good morning, Judge McNally. If you have a second, I just wanted to introduce you.
Sure, come on up. How are you?
This is Miss Laura. She just started a couple of weeks.
Come on up. This way, right here, right here, right here, right here. Yeah, walk right in through that door there. Come on up. Absolutely. You started with prosecutor's office?
Yes, I
What's your
did.
name?
Miss Sarah.
Nice to meet you. Is that your person?
Yes. Fargo.
Barda?
Fargo, like the bank.
Oh, okay. How you doing? Nice to see you.
You.
So you're starting in the prosecutor's office?
Yes.
And where are they gonna have you?
General screening.
Okay,
Probably.
good.
Like
You
our-
passed the bar, right?
Yeah. I just took it in February, so I'm waiting for my results. They come out real soon. We're gonna find out if all the BCs are attorneys. Yeah.
A week or two.
I check them every day.
You passed. You passed. Don't worry about it.
Thank you. I know just one of the PCs, she actually reached out to me asking what she can do. A lot of the PCs, like, some of them don't do that. I was like, I was the only one who used to do that.
Right.
So I definitely think she's gonna end up being really, really good.
I'm sure you are.
Yeah.
I'm sure you are. Well, it's nice to meet you. I hope to see you around here.
Anyway, sorry to stop your dog.
You're fine. You're fine. Thank you very much. Nice to meet you.
Well,
Take care. All right, where's that one with Mr. Credit acceptance versus Amy Tank, 2504669. Mr. Begg, your appearance.
Good morning, Your Honor. Jay Begg, BAIG P36820 on behalf of plaintiff.
Defendant failed to appear, right, Jennifer?
Correct.
You can take a default. Go ahead.
Thank you. The default judgment, numbers $5,352.28 in damages, costs $93.84, statutory attorney fee of $75 for a total of $5,521.12, Your Honor. Thank you.
Defendant failed to appear. Case is scheduled for 9. It's now 9:28. Defendant was given 15 minutes. Default judgment letter in favor of plaintiff against defendant. 552112 is the amount. I'll ask you to submit your judgment today. Anything else?
Nothing else, Your Honor.
Thanks a lot. Have a great day.
All right.
Yep.
One more. Yep.
Which one's that?
LVNV funding versus Cortina
Thomas, LVNV versus Cortina Thomas, 2504580. Good morning, ma'am. Your name?
Okay. Good morning, Your Honor, respectfully. My name is Cortina Thomas.
All right. And Jennifer, you guys, she filed a motion in your name, Mr. Begg.
Jay Begg on behalf of plaintiff. We talked about, we're unable to settle it. She would like her motion to be heard.
Jennifer, what kind of service was there in this case? I need that document, or at least you need to tell me when how the service was. Was this alternate service?
It does look like it was alternate, and I can print those if you'd like.
You live at 18104 Pine East, ma'am?
No, sir, I do not.
When did you live there until?
I did not live there. I moved back from Ohio and I used that address. It's a family home, a family member's home, and I used the address. I always put my P.O. box on everything. So I did, I was already in a hearing with a court case with LVNV funding, where they had been putting documents on the family member's home regarding me. And I let the judge know the hearing that I just had that is not my address. And they were supposed to, I guess, make that known that I use my P.O. box, that I do not live at that address.
What judge?
I'm actually doing another case for, who's my judge for that one?
Well,
I go back to court on July the 7th for that.
Are you in this courthouse? What does that have to do with anything?
No. I was just saying that I did make a correction for them to, I don't know why they keep sending my mail to the wrong address is what my point was.
Well, what case? Are you talking about a case in this court or some other court?
Your Honor, if I may, she does have a case in front of Judge Heston in which we did update her address to a P.O. box on March 19th. So just recently.
And you did it on this one too. The defendant one previous address, I think. Well, it says 118-104
They keep putting that same address on there, but that's not my address. I asked the court, could I use my P.O. box? Because that's something that I know I frequently go and check my mail on a regular basis. And the judge agreed to that. So
that's nice of her. I'm not worried about what happened on that case. I'm worried about what happened on this case.
This case, Your Honor, I never received any documents. I was never served any papers regarding the court case. I would have been there. I went to the last one. I would have went to this.
Ma'am, would you let me ask you a question, please? You said the family owns a place, or at least is in control of the place, whether as a tenant or otherwise, at 18104, correct?
Correct.
And you gave us that address initially, right?
No, I did not. I've never given that address, sir. Your Honor, I've never given that address at all to anyone. I've always used my P.O. box. I've never given that address. I don't even know how they were aware of that address. Like I stated,
slow down. Do you owe this one?
I'm not aware of the total amount. They still haven't even told me the amount that they're saying that I owe. So I have discrepancies regarding that because of the fact that I paid into my debt. So I do not, I'm not aware of what they're saying, my total claim, the total amount that they're trying to claim that I owe them.
You received a copy of the judgment, right?
I did. I received a judgment. I didn't receive any paperwork from them. What happened was,
Ma'am, please just answer my question.
Okay.
Did we or did we not send you a copy of the judgment that you received? Yes or no?
I received a notice to appear. That's the last notice that I received. I did receive that.
You didn't receive the judgment?
No.
What prompted you to come in here and file a motion to set aside the default judgment then?
That's what I'm saying. So when I was when I found out about the judgment, it was the court had already appeared. I had just went to court before for LVNV funding prior to. So I had reached out to the court because I received a statement saying that I had a judgment against me. And I said, well, what is this?
Myself clear. What caused you to file a motion to set, ma'am?
I received the judgment. I received the judgment saying that I had a judgment.
That's
you know
what
I mean?
I said
the
to
judgment
you.
Paper.
You just told me you didn't
misunderstood. I'm sorry, I misunderstood. So when I received the judgment, I contacted the.
Slow down. Slow down.
Okay.
You just got done telling me you did not receive the judgment. Now
I
you're
did
saying,
receive the judgment. I'm sorry, I'm referring about I got another court case, that paperwork that is in front of me too. So I'm sorry. I'm sorry. I apologize, Your Honor.
okay, just
I
stop
did
talking.
receive the judgment.
Stop talking. Please. You also told me, after you said that you didn't receive the judgment, that they never told you how much you owed them. If you received the judgment, it's right on there, correct? Do you have a copy of the judgment?
I'm speaking
in
about the
front-
conversation that I just, okay.
I don't know. It's big. I'm wondering if my forehead says I want to be interrupted. It must. It must say that. It has to. You have the judgment in front of you?
Yes, I have the judgment now in front of me.
You see what it says that you owe?
Correct.
All right.
I do see it.
Okay, so now you know what you owe. How much do you think that you owe? Give me the exact dollar. Don't just tell me I made a payment or I made payments and I don't owe this much without telling me the exact amount that you owed.
I can't give you an exact amount
Well, then how do you know that you don't owe this?
because like I stated before, Your Honor, I have paid into my debt. I was paying into my debt until I lost my employment. So I was paying my debt every week, every 2 weeks that they had me paying until I lost my employment.
All right, Mr. Banks.
So I'm not aware. I have to go back and find my
You don't know.
actual receipts and things.
You said it 45 seconds ago. You don't know how much you owe. Mr. Begg?
Not the exact amount, not today. I do not.
Well, you're coming to court and you're asking me to set aside a judgment. And I have to find that you're interrupting me again. You're starting to. And I have to find that there's a meritorious defense and good cause to set aside the default judgment. You're saying you weren't served. Somehow they had you at this family-owned location. And that's where all the paperwork was sent. And they obviously must have applied for alternate service. If you didn't live there, you couldn't have been served personally there, but they can serve in certain circumstances by alternate means. First class mail, tacking, certified mail. So I'm kind of surprised none of your family members that lived there would have told you about this, but that's neither here nor there. I'm going to look at the proofs of service. Mr. Begg, tell me how much the interest rates are on this one.
Let's see, this should, post-judgment interest is at 4.72%. I told her her balance is $6,581.89.
What's the pre-judgment interest at?
I'm not sure here. Let me see if it's
Take
in
your
here.
time.
It looks like pre-judgment interest was waived. If I'm looking at the default judgment.
For somebody's bringing to me that, right? The proof, the service?
Yes, Gina's on her way.
Thank you. Okay, so on December 21, somebody answered there and said you were not home. What do you want to say, Mr. Begg?
She doesn't deny the original creditor. She was trying to argue that she had no contract with LVNV funding, but she's not a party to an assignment, so she has no standing to to challenge it. There's definitely no meritorious defense here, and the alt service was properly ordered and completed.
Anything else, Ms. Thomas?
Yes, Your Honor. Respectfully, I just asked the court to set aside the default judgment. I wasn't properly served. I just wanted a chance to file my answer. I still didn't, like I said, I just didn't know the total, what they're saying that my total amount of the debt was. Like, that was my question. I didn't argue with anybody. You know what I mean? He asked me a question and
But you know now, right? Because you found the judgment that you said you didn't have. You know, right?
Yes, sir. Absolutely. I know today. Yes, I do.
Well, you would have known from the time you got the judgment, right?
I got the judgment. Yes, I wanted to be able to appear in court. I didn't want a judgment filed against me. I wanted to be able to have a say, to at least prove or have a chance to argue my point. I wasn't able to appear in court, so obviously a judgment was already rendered against me to pay total amounts of court costs and the judgment, which I felt was unfair because I wasn't, like I said, I wasn't able to come and at least state that, you know what I mean, just be able to give my answer or at least ask the judge, ask Your Honor to at least be able to have them show me my total amount, prove to me my total amount. Because I have paid into them. This is not a debt that I just got and didn't pay into. I was paying my portions of my debt on time. I lost my employment and my home, and so that became an issue.
You filed your motion on March 25th, which would have been after you received the default judgment.
Yes, sir. I did.
So if you were coming to court, you needed to come forth and say, this is all that I owe and here's why, in a written document. You didn't do that.
I didn't know that. Right. I didn't know that. When I spoke to the court clerk, I'm sorry.
Good.
Okay. So when I contacted the court, she explained to me that a judgment had been rendered and that this is what I needed to do to have it set aside or at least get a court date to speak with Your Honor. And so that was what I did. I was so fearful of the default judgment being placed against me. I came in immediately the next day. And so that's when she told me that I had to file this paper for XYZ, pay this money, file this document. You're going to write on the document what you feel is the reason why you didn't appear in court. And that's what I did. I didn't know I had to do, you know what I mean? I didn't know I needed to make another statement in regards to the monetary portion of the judgment. I didn't know that.
So I have to find good cause in a meritorious defense, and I just can't do that, Ms. Thomas. They properly got alternate service. Ma'am, let me finish. They complied with the order for alternate service. You didn't answer the complaint. You don't know what you owe. You're just saying you paid some of it. A lot of people pay some of it. I cannot find that there's a meritorious defense here. I'm sorry. I'm going to deny your motion to set aside default judgment. If you would like to, you can file a motion for installment payments, and or we can even do that now, Mr. Begg, if you'd like. And I will be glad to accommodate you with a hearing, determine how much you can afford to pay weekly or bi-weekly or monthly. I'll be happy to do that now, and I'll waive a motion fee if you choose to do that now. Would you like to do that?
I mean, if that's all I have, yeah, because you saying you're not setting aside the judgment, I can't even fight for that. So at least I can't afford to give them, I don't have $6,000 to give to anybody.
Ma'am. Really, I'm not going to argue with you. If you want me to conduct that hearing, I will, but I don't want to hear another word about my ruling. You can appeal that if you don't like it. Please feel free. I'm not always right. If you want me to do that now for you, I will. I'll swear you to an oath And Mr. Begg can ask you questions and I'll ask you questions and I'll figure out how much you can afford to pay on a weekly, bi-weekly or monthly basis. Do you want to do that?
Do I have to do that today? Can I have a hearing for that?
No, you can do it. You can do it later, but you're gonna have to come in and file a motion then. Okay? And you can request that the motion fee be waived if you qualify for indigency status under the rules, okay? So yeah, you can come in and fill out your motion. Right now, counsel, send me an order denying motion to set aside default judgment. You file your motion. I do it sooner rather than later, and we'll set it for hearing, okay? Thank you very much.
What is the motion
Thank
that
you,
I need
Your
to
Honor.
set?
Counsel, wait. You can file a motion for installment payment order. Okay? Good luck to you both. Thank you. Derek
Thank you.
Tanbelda Fernandez, 25W707530. Defendant is compliant, community service and domestic violence program completed, mental health treatment compliant, balance zero. The defendant's inpatient, and I just got this step from the prosecutor. Case dismissed. This was taken under 7694A. I'm going to waive his presence today in light of the fact that he's in an inpatient facility. Case dismissed. Defendant compliant. Defendant could not appear, but I'll waive presence as defendant. Is entry. All right, that's what I'm going to do. All right, now, what else do I have here? Do I have Capital One versus Scott R. Voida?
Your Honor, the parties are still in a breakout room.
Do I have Betty Breeding versus Dakota Richtor? Come on up here, please. 2600603.
Where's the vote here?
Morning.
You two want your name, ma'am?
Oh, Betty Brady.
Where's the vote? Next one.
Sure, your name? Do you want to talk about this out in the hallway? Yeah.
I gave him chances to blame me.
Are you a heating and cooling guy?
I do it on the side.
You want to go talk, see if you can resolve it?
I mean, we've talked, obviously we're here now, we need to go.
Okay.
All right.
I don't believe what she's trying to get was necessary.
Fair enough. You guys, by pursuing the small claims division, are giving up certain rights. Each of you are giving up the right to a jury trial. Each of you are giving up the right to a lawyer. Each of you are giving up the right to appeal my decision, and to the extent that you might be entitled to it, plaintiff, you are giving up the right to seek in excess of $77,000. It might, has it gone to 7,500 yet, Jen?
No, Your Honor, it's still stated
Still
7,000.
7,000. Okay, they're always raising it every, what is it? Can be 8 months or a year, but anyway, 7,000 is the max, but you're only paid for 700. You don't have to give up those rights. If you want to preserve those rights, just tell me. I'll remove the case to the General Civil Division. I'll still be the presiding judge over the case. But if you proceed in small claims, like I said, you're giving up the right to appeal my decision, the right to a lawyer, the right to a jury trial. Do you understand that, Ms. Breedy?
I do.
Do you understand that, Mr. Richtor?
Yes.
Do you wish to give up those rights and proceed here or have the case removed? Ms. Breedy? You waive those rights? Mr. Richtor?
Yes.
You waive those rights? Raise your right hands. Do you have any witnesses? I'm asking you.
I have a person that did the work.
Where's he at? Is he coming today?
No, he's at his job.
You want to call him?
My cell phone, because when I was leaving.
Well, I'm just telling you, hang on a second. I don't know what you're talking about with the parts here you're talking about. If you think he did something wrong, you're gonna need to prove that.
Okay. He never finished the job.
Is that true?
I have to get a piece of metal made.
All right, stop. Let me just have you both raise your right hands. If I need to adjourn it, I will. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. Ms. Breeding?
Yes.
Mr. Richtor? Okay, tell me what happened, man.
Okay, my furnace went out in December.
This up 25.
Yes.
Okay.
My boyfriend, he goes up north, he told me to call LV to have me do my furnace. So I called him. I gave him $2,000 to get the furnace and pay him for the work. He brought me the furnace, hooked it up, and didn't have the plan to go to the vent. So he put a fan on a brick, shoving the heat up into the vents. So every week I would call him. And he kept telling me that this plan was being made. And 3 weeks had gone by, and I told him, I said, I can't continue to push the heat up to the vent with a fan. The gas bill that month was almost $400. And I wasn't really getting the heat in the house that I needed.
Is that true what she said so far?
To a certain point, yeah.
Well, what point isn't it true?
So I told her that I will be back I had to call, there's a place in Livonia where I get the metal made, basically just to connect it. That part was true. I needed to come back for that. The metal wasn't made yet, so I never returned back. Everything else was done with the furnace thing.
How much of the $2,000 did you earn?
Only made $400 off that job.
And he charged me $800.
$2,000 altogether with material.
So you charged, the deal was you were supposed to install everything, including parts and labor for $2,000, right?
Yes.
And you received all that money, right? And you had to hire somebody else to do it?
I did. So
You have their invoice?
I can get him in I paid him $800 to finish the job.
Why didn't you bring your invoice?
I don't have it anymore, sir. But it's done.
Who'd you hire?
Joe Walker.
Is he with the company?
He's a contractor, yeah.
Joe Walker.
Yeah.
You call Joe Walker and have him zoom in?
Don't hit my phone, sir. I forgot the phone, so I just had somebody come to the door and tell me my friend got crushed and killed today, so
Oh my God, I'm sorry.
I'm not.
Why didn't you finish the job and why isn't she entitled to the balance? It was supposed to be 2,000 and she gave you 2,000.
Yeah.
And she had to pay an extra 800.
So I was gonna go back when the part was done. The part was done, he called me, she's already got it.
This was December, right?
Somebody else.
It was cold.
Yeah, so her furnace was out, the heat was, she had heaters in the basement behind. That, I believe, is why her electric bill was so high.
Yes, no.
Well, you're coming up with 700,
With
man.
the new furnace, it runs less gas, so there's no way it could be running more. There would be no way it could run more.
How are you coming up with $700? Tell me.
After he brought the furnace over, he kept telling me for 3 weeks that this part was being made. He never come up with the part. It was really cold in my house, so I had it done by another person.
I know.
He made the plan right there at my house.
So
It cost me $25 for the plan.
So it was 2,800 is what you paid out on this. Well, why are you only suing for 700?
Because I told him on the 800 that he owed me, he could keep $100 for his trouble. So then he told me it was 800 to carry the furnace down my stairs. And he gave my old furnace to one of his friends for metal. And I said, $800 to carry it in my basement, not hook it up. They don't even have a receipt that I can't even get the warranty on this furnace.
The furnace was working. The only thing that I needed was the plug piece that connects from the furnace to your ductwork that blows it into your house. It was literally maybe 10 inches, the piece.
Why did,
You put dryer parts on my furnace runner.
I read that.
Yeah.
In the state of Michigan, you can use.
I'm just curious as to why you did not sue for 800.
I told him to keep 100 for some troubles because I didn't want to hear about how he carried my furnace.
He kept how much did you keep of the 2,000?
I only made 400. The rest of the material.
He told me it was 180, then he told my boyfriend it was 40.
And then the piece of metal that I had made was 160.
Well, you never had it made.
I did.
And you're under oath. You understand that, right?
Are you talking to me?
Yeah, I'm looking at you.
Yeah, I am.
You're under oath. And you're telling me under oath that you paid $800 to have the rest of the work done.
I did, sir.
Do you have any reason to dispute that?
My friend, one of my buddies, told me that the guy who she hired, he also did more work than what I did. He brand new power, a breaker, a line. That right there is $800, Your Honor.
Is that true?
He did, but he charged me 800 for the rest of the job as well. He only charged me 800 for all of it. Because he felt bad that I got ripped off. In the middle of the winter, I had no heat. A fan doesn't blow the heat up to my upstairs.
People always rise.
Not,
I don't know why you didn't take care of this earlier. I don't know why you undertook. I'm looking at him. I don't know why you didn't take care of this earlier.
Well, the shop that I called told me that they were booked out. I had the part made. When I did reach out to her, she said that she's already completed it. On top of that, her boyfriend called me, cussing me out and going bonkers. So
Well, I mean,
and I understand that.
Anything else? No?
That was it, really. I mean, basically, the 160, I believe, the plumbing piece, I believe I would pay that. That part was not finished, yes. Everything else was hooked up, though. The return, the gas, the CO2 vat, all that was hooked up. The furnace was functioning.
Inherent in something like this is the fact that it has to be done within a reasonable time. You have a reasonable period of time to fulfill the contractual terms. If you're making people wait for 3 weeks, I don't care if you have to drive the Escanaba to get a plumbing or make it yourself or do what else, you breached the contract. She had the right to go out and hire somebody. She did that. Judgment for plaintiff, $700 plus your filing fee of $68, your total $768. Can you pay that today?
No, I'm not working right now.
When can you pay it?
I start my job next week.
Where?
With sewer and water, Monroe.
How much you going to make?
I think I'm starting out 22 an hour.
Tell me how much you can afford to pay weekly.
Maybe $50.
Do you have a family?
I do. I got 2 twin daughters. They're 9 months old.
When is your first check going to be?
2 weeks from now. From the day I start Monday, next Monday. So it's 2 weeks from now.
So you start on April 27th, right? You pay $50 per week to the plaintiff beginning May the 15th. Okay, so that's the best I can do, Ming. Okay?
Can I just talk for 1 sec?
Sure.
I gave him the option to pay me weekly, and he kept telling me he was gonna send me $100 through.
If he doesn't pay this, you can move to set aside the installment order. You can subpoena him for a creditor's exam, and you can garnish his wages, but you'll have to talk to a lawyer about all of that.
Lawyers.
Okay, so talk to him. If the defendant doesn't pay you, as I outlined, then you can undertake collection proceedings, all right?
Thank you, sir.
Go down the hall, both of you, get a copy of the judgment. Good luck. Thank you. What else have I got here?
You're on a Capital One in Scott Wooddoyas.
And that we're going to set this for sentencing. Is that accurately stated?
It is, Your Honor.
Ms. Cunningham, how old are you?
52, sir.
How far did you go in school?
I graduated high school.
Are you able to read?
Law enforcement.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir. No.
Are you taking any medications?
Yes, sir. I take mental health I take medicine for my anxiety and my mood swings and depression.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes, sir.
We've had some discussions about your case. If you enter a plea of guilty to this charge today, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. I'm going to conduct a level 2 pre-sentence investigation. We're going to come back here in about 8 weeks for sentencing. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir. They haven't.
I have a document entitled Change of Plea and Entry. On the second page, there is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Clark before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to 1 count of theft from a person in a protected class. It's 4th degree felony. It's punishable by up to 18 months in prison and a $5,000 fine. There's no mandatory prison, but if I do send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. Harris, what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, as to count 1, that on or about December 15th of 2025 in the village of Waynesville, Warren County, Ohio, defendant Luana Mae Cunningham used stolen credit cards obtained from Jerry Johnson, who is 74 years old, and made unauthorized purchases in the amount of $1,925.20.
Anything on those facts, Mr. Clark?
Nothing on the facts, Your Honor.
Ms. Cunningham, did you hear those facts?
Yes, sir. I did.
Do you admit that they are true?
Yes, sir. I do.
Do you understand the rights you're giving up by entering a plea?
Pardon me?
Do you understand the rights that you are giving up by entering a plea of guilty?
Yes, sir. I do.
What's your plea? Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go to the matter of the sentence today. Instead, we're going to set this for sentencing. That's going to take place in about 8 weeks. Here's what I'm going to do, Ms. Cunningham. Your attorney tells me that you have someplace to go, right?
Yes, sir.
All right. Right now, you have a GPS requirement on your OR bond. I'm going to lift that requirement on April 23rd at 1 o'clock. So what I want to do is give my pretrial people some time to get over and interview you at the jail before you go back to Franklin County, and we'll see you back here for the sentencing. So you will be released on the 23rd at 1 o'clock. Also, that gives you time to have some family member or somebody here ready to pick you up.
Thank you so much, Your Honor.
Okay? Anything else?
And thank you. Thank you, sir.
All right, that's all.
Thank you.
Next is the case of the state of Ohio versus Emily Bird. This is case number 26 CR 43291. Present before the court is Ms. Bird, right? You're Ms. Bird, right?
Yes.
Represented by Mr. Clark. We have Mr. View from the prosecutor's office, Officer Fisher from probation. We are here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor. Yes, Your Honor.
Any reason not to go forward with sentence today?
No, Your Honor.
We have 17 days of jail time credit, no restitution, right? All right, Mr. Pugh, on behalf of the state.
Nothing additional from the state, Judge. Thank you.
Officer Fisher, anything from probation?
Nothing further, Your Honor.
Mr. Clark?
Your Honor, we just ask that the court adopt the recommendations, and sounds like she's doing better and want to stay on that path.
What do you want to tell me about this, Ms. Bird?
About the whole situation, I guess.
You have the right to tell me anything that you would like.
Honestly, I feel like I needed it to happen in my life for me to realize everything that I've been putting myself and my family through. I've been doing tremendously better. My life is a whole lot better. Everything's gotten a lot better. And as much as I hate what happened, I definitely believe that it needed to happen.
All right, I'm going to put you into my community control program. I'm going to do that for a period of 3 years. I'm going to put you on basic probation. I'm going to impose upon you the standard rules of probation. Delegate your officer the ability to make special or additional conditions as they see fit. Right now, it's going to be a special term of your probation that you, can we get her into thinking for a change with a low mod?
Yeah, it's because of the moderate portion of it. She would be eligible.
Okay. We'll have you complete the court's thinking for a change program. Also complete 40 hours of community service. I'm going to give you credit for the 17 days that you have already done. I'm not going to impose a fine. I am going to impose the costs upon you. If you violate the terms of your supervision or you leave the state without permission, I can send you to up to the maximum penalty in the case, which is 36 months in prison. I'm not going to impose a fine, but I am going to impose the costs. Anything else we need to do? Anything I forgot?
No, Your Honor.
All right. Finally, Ms. Bird, you do have the right to appeal this to the 12th District Court of Appeals in Middleton. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you at no charge. Good luck to you.
Appreciate it, Your Honor.
Capital one. Okay. I thought I called that case, did I not?
You did, but they were in a breakout room.
You, Jimmy. Capital One versus Voida. Did I put it up there? You got it? What time is that? What time was Capital One versus Voida?
9:30, Your Honor.
I swear, are you sure that you have it down there?
I only have 3, Judge, and I don't have that one.
Not here. Oh. It was just here a few minutes ago. Capital One versus Guard our Void. 2504390. Names?
Morning, Your Honor. Dylan Clark, P88474 here on behalf of plaintiff.
Your name, sir?
Good morning, Your Honor. Scott Rollin Voida.
Any resolution on this one, Mr. Clark?
Yes, Your Honor. We came to a resolution in the form of a conditional dismissal.
Okay.
Mr. Voida has agreed to pay the amount of $3,907.48 in 12 monthly payments of $326 beginning on or before May 21st, 2026.
Before beginning when?
May 21st, 2026, continuing on the 21st of each month thereafter for that period of 12 months. Should Mr. Voida make payment as agreed, plaintiff's dismissal will be deemed with prejudice. However, if Mr. Voida fails to make payment as agreed, then plaintiff reserves the right to reinstate the action for the full amount minus any money that's already been paid.
Understand what he's saying, Mr. Voida?
Yes, sir.
Is it Voida, Woida, correct?
It's pronounced Voida, Your Honor.
Okay, that's what I thought you said. So my apologies. Mr. Voida, he tells me you're consenting to a dismissal, again, in favor of the plaintiff, not in favor of, the case would be dismissed for the amount of $3,907.48, and it's going to remain dismissed. And in fact, will be dismissed with prejudice if you make all the monthly payments commencing on, beginning on May 24th or 26th and the 24th of every month thereafter until paid in full in the amount of $326. Is that your understanding? And is that how you wish to proceed?
Yes, Your Honor.
Now, if you don't make a payment, if you miss one, he's going to move to set aside the dismissal order, reinstate the case, and enter judgment. Do you understand that?
Yes, Your Honor.
You agree to that?
Yes, Your Honor.
Does she have your permission to sign your name to that proposed conditional dismissal? He would submit it to me, I would sign it, and then you would receive a copy.
That's where they sign, like the court or you guys sign on my behalf, correct?
I'm not going to sign on your behalf, but does Mr. Clark have your permission to sign your name on your behalf?
Yes, Your Honor.
Okay, so you can do that, Mr. Clark, submit it. Mr. Voida, do you have any questions at all, sir?
No, I appreciate your time. And I seen your video online. I am in a car, but I'm parked and I'm not driving. So just FYI.
Have a great day. Thank you.
You as well, Your Honor.
Your Honor, I do want to know one thing before we're off the record here. The payment date will be the 21st, not the 24th.
I'm sorry. So the payment's going to be due on the 21st, not the 24th. You understand that of every month?
Yes, Your Honor.
Okay. Thank you very much. Have a good day, guys. Thanks.
You as well.
Thank you, Your Honor. I do have one more matter in front of you this morning. At 10 a.m., Capital One Discover versus Huey.
Am I able to leave the courtroom, Your Honor? I apologize.
You're all set.
Okay, thank you.
Thank you.
Your Honor, I don't have Mr. Huey here yet.
Oh, I see. Huey. I thought he was saying Dewey. Okay. All right. Capital One versus, Citibank versus Robert Nickrand. 2505159.
Your Honor, both attorneys are here, but they're in a breakout room.
Okay. Thomas Burton versus James Metzger. 2601197.
Plaintiff is on Zoom. He is out of state. Defendant has not checked in, but it was at 10, so I don't know if we have to give it till 10:15.
Yeah, I'm going to have to. Mr. Burton, just bear with me, okay?
Yes, sir.
You're in West Virginia, huh?
Yes, sir.
Okay. Well, Mr. Metzger hasn't shown up, but I give everybody 15 minutes. So if he isn't back by then, I'm coming and entering a default judgment. So I'm on standstill until the lawyers get out of the break room and or Mr. Metzger and or Mr. Huey show up, correct?
Correct, Your Honor.
All right, we'll take a recess. Thank you.
Mr. Burton, I'm just going to place you in the waiting room for right now. The judge should be back on right about 10:15. We just have to give that 10-15 minute window, okay?
Sure, no problem.
Set it for sentencing to get some more information before I do the sentence. Mr. Rhodes, are you going to plead to the charge of use of cocaine, which is a misdemeanor punishable by up to a year in jail and a fine of up to $2,000? Use of cocaine?
Yeah.
It's a misdemeanor.
Yes, sir.
Anybody threaten you to get you to do that?
My lawyer.
All right, she threatened you to get you to.
We can't mess around about that, okay?
This is serious business. I had one guy say, yeah, my wife told me she'd kill me if I didn't plead to this. But I mean, if your lawyer, the prosecutor, or probation officer, the judge, anybody threatened you to get you to try to plead to this?
No.
or promise anything other than the plea offer. All right, you understand that if you do plead to this, you're giving up all these rights on the advice of rights? Yeah. Well, let's talk about this case. According to the affidavit, there was something going down at North Main Shell. And they found a baggie with some drugs in it. And you'd been in there sometime earlier and apparently dropped that baggie. And then they watched the video and realized it was you. So had you had a baggie of cocaine that you accidentally dropped at the Shell store?
Yeah.
And had you used some of that?
One more time?
Had you used some cocaine?
No. Not at the time.
All right, well, had you used some, like, within a
In my
day?
life, yeah.
All right, but
And Your Honor, we're doing the plea to
Based
the
on-
possession of cocaine as the lesser included being use. He's not admitting to using it actively, just having knowledge and possession of it.
is that correct?
Yes, sir.
Yes, oh, I'm sorry. So everybody agrees. We're all in agreement. But if I gave you a test right now, what would that show?
A lot of marijuana.
Well, marijuana is lawful for adults to use for recreational purposes. If I put you on this probation or 7411, you're gonna be able to smoke weed. You
I know
understand?
that.
You willing to do that?
Yes, sir.
All right. I'm gonna set this out a little bit.
This is on. Okay, so next we hear.
Today for a pretrial, but it's my understanding Ms. Conger is going to enter a plea of guilty to the charge of possession of drugs, and we're going to go forward with ILC. Is that accurately stated?
It's accurately stated, Your Honor.
I know it hasn't been long since we went through all of this, Ms. Conger, but I want to make sure that I have a clean record in this case also. How old are you?
44,
How far did you go in school?
high school, graduated.
Are you able to read and write English?
Yes,
Are you under the influence of drugs or alcohol?
no,
Are you taking any medications?
yes.
What are you taking?
Take Boost Bar for anxiety and melatonin for sleep at night.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No,
Are you a United States citizen?
yes,
Other than the fact that we're going to put you on ILC, has anybody made any threats, representations, promises to make you plead guilty to this against your will?
no,
You have a plea form somewhere?
Right here, Your Honor.
On the plea form, there's a signature on page 2. Is that your signature?
yes, sir.
Did you review this document with Mr. Borger before you signed it?
I did,
Are you satisfied with the representation you've received in the case?
I am,
You're going to enter a plea of guilty to 1 count of aggravated possession of drugs, 1 count of drug abuse instruments, the possession of drugs, 5th-degree felony, punishable by up to 12 months in prison and a $2,500 fine. If you violate the terms of your supervision and I do send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Your rights really haven't changed that much since we went over them a few months ago. You still have the right to make the state of Ohio prove that you're guilty of this unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf. You have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to put you on ILC subject to the same rules that you're on now. So, is that what you want to do?
Yep.
Mr. Harris, what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about October 7th of 2025, after being arrested in the city of Lebanon on an outstanding warrant, Heather Conger was found in possession of several syringes as well as one controlled substance that was sent to the lab. It did test out as methamphetamine, 0.08 grams.
Who does the reimbursement get paid to?
Lebanon Police Department.
Okay. Anything on those facts, Mr. Borger?
Nothing on the facts, Your Honor.
Did you hear those facts, Ms. Conger?
I did,
Do you admit they are true?
yes,
Do you understand the rights you're giving up by entering a plea?
yes,
What's your plea?
guilty.
I'm going to accept your plea of guilty. I find that it's been made in a knowing, voluntary, and intelligent fashion, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to grant the motion for intervention in lieu of conviction, order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan, which is identical to the treatment plan that we already have. And we have $250 in reimbursements to Lebanon PD. Anything else?
No, yeah.
All right, Officer Bridgman, we'll meet with you and go over the rules. So you need to go down to probation, meet with her before you leave. All right, that's all.
Thank you, Your Honor.
Thank you, Your Honor.
Any resolution?
Not at this time, Your Honor.
All right, we're going to do the same thing then.
Well, actually, I
Discovery-
think today is a motion for summary judgment, actually.
Oh, that's right. That's right.
It appears
Yeah.
my client doesn't believe in answering motions for summary disposition, so I'm going to have to indicate I can't oppose it because I don't think he filed an answer in an affidavit.
Well,
I can say, Your Honor, that we'll likely could probably just move forward with the motion for summary judgment today. Attorney Apps and I have also made settlement discussions. Despite the judgment, this is still most likely to end up in some sort of payment plan and settlement.
yeah, but they did file a response.
Yes, they
An
did.
affidavit too, sir? An affidavit too?
No. Let me double check that.
I thought it was a two-part requirement.
He's arguing basically that discovery is permitted but we're done with discovery, aren't we?
Yes, we are, Your Honor.
We're not.
Yeah, go ahead.
No, you go ahead.
This attorney tends to send appearance counsel when oftentimes he's making arguments in the answers that are not support. I don't even know if supported is the right word, but not properly. The proper actions have not happened prior to him making the arguments, such as arbitration. So I believe we could just move forward with the motion for summary judgment.
Go ahead.
Okay. Sorry, 1 second. I clicked off to go to his answer. Let me just bring it up 1 sec.
I think the term's called a responsive pleading, and none of the people I sub for ever seem to know what that means.
All right, I'll read this in real quick.
Stop subbing for some of those people, Mr. Apps. I don't know what to tell you.
I'm sorry, sir?
I said, maybe you should stop subbing for some of those people or all of them.
No, I don't stop subbing for him, Mr. Apps. We what fun would we have?
They pay me for doing this, sir, and otherwise I have to find a real job. So I'm not going to kill the goose.
Go ahead, Miss.
Sure thing. Motion. I'll do this real quick. Motion is brought under MCR 2.116 C9 and 10. Defendant has failed to state a valid defense to the claims asserted and has failed to assert facts giving rise to issue of material fact. We attach as Exhibit A copies, detailed account statements showing knowledge and use of the account. Defendant's answer, potentially not filed correctly, doesn't really touch on any of that particularly well. Brings up arbitration, even though they never tried to compel arbitration. So based on our filing, we basically stand on our document and ask for motion for summary judgment this time.
Any response, Mr. Apps?
I think has a very eloquent explanation, sir, and I have no defense.
I'm going to go ahead and grant plaintiff's motion for summary disposition pursuant to provisions of MCR 2.116 C9 and C10. I'm going to ask you to give me your breakdown and we'll enter a judgment now. Okay, counsel, go ahead.
Let me bring it up. Second. All right, so we have original damages of $2,640.46, court costs of $157.26. That's 75 in filing, 20 for motion, 62.26 for service, for a total judgment amount of $2,797.72. This particular creditor does not seek any statutory interest rate.
All right, judgment will enter. So summary disposition granted, judgment will enter in the amount of $27.97.72 in favor of plaintiff and against defendant. So you can submit your judgment. I appreciate it.
Your Honor, I
very
do
much.
have a judgment
I was gonna
submitted
say,
with the motion, so I've
It's page
sent it to your
15,
box.
but I can resubmit if necessary.
Whatever you
I've
want,
sent it
Jen.
to his
Bring it-
signature box. You're good, Judge. It's there for you to sign.
Excellent.
It's in the back of the packet?
No, on M file. When you go in
Right.
to log in later, it'll be there.
Got it. You're all set, gentlemen. Have a great day. Thank
Thanks.
you.
And let me
thank you,
just check
everybody.
in. Can I just check in real quick on McDaniel? It was still on the ROA, but we did file a dismissal.
That when we have off, Your Honor. We
Okay.
did get the dismissal.
So you're
Thank you.
all set.
Thank you very
Thanks.
much, Your Honor. Have a good one.
Thomas Burton versus James Metzger, 2601197. Mr. Burton, state your name.
Thomas Burton, sir.
Oh, this isn't good. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got.
Yes, sir.
Your page, my page cuts off. You gave him 144611 for custom what? The V there is all I see.
Oh, they're custom truck parts, sir.
And they took the money and never provided the parts.
Yes, sir.
And are you still out $1,446 and
Yes,
11 cents?
That's correct, sir.
Okay, you're welcome.
I'm gonna go ahead and give you a default judgment. This is your day to be a lawyer if you want. I'm just kidding. Anything else? You have
No, sir.
$1446.11 plus you have your filing fee in the amount of $18. Do you have any other out-of-pocket expenses?
Yes, Your Honor. $51 to send him additional documents. That was
To
sent
send
last
who
week.
additional documents?
Mr. Metzger, there were follow-up documents that were submitted to the court and submitted to him as well.
And Your Honor, his filing fee was $50 and there was an $18 service fee.
Oh.
So it was $68 total.
What's he talking about with the documents, Jennifer? Was that in conjunction with the case or beforehand?
That may have been him sending him the documents that are printed in your packet, because he would have
Nice.
mailed a copy to opposing party of everything he was filing with the court.
Yes, Your Honor. That's it.
Where'd you have the documents printed at?
I printed them myself, and then I had the UPS store ship them for me.
I
Certified
see.
mail.
And that was $56?
$85, sir.
So I got 85 plus 50 is 135 plus 18 is 153. On my math, you're getting 1599. And if you think I'm wrong, please tell me. 1599.11, because I'm giving you the $85, the 15 and the I'm sorry, the $85, the 18 and the 50. So 1599.11. We will send out the judgment and you're all set. I wish you well.
Thank you, Your Honor. I appreciate it.
Have a great day. Thank you.
One
Sorry
last
you-
question, Your Honor.
Yeah. If
Once
he
you
doesn't
guys
do
send-
anything in 21 days, we're gonna have to figure out a way to collect. You could do a creditor's exam and perform that by Zoom. He'd have to come here. But you're gonna have to, I would talk to a lawyer, or you can do the best research you can online. I can't really advise you. You can garnish wages, you can garnish bank accounts, you can garnish tax returns, but you're gonna need other information to do that. So
Your
probably
Honor.
gonna want a creditor's exam, require him to bring all of his pay stubs and tax returns, house deeds, bonds, stocks, car titles, etc. Okay?
Your Honor,
Understand,
if
Your
I
Honor.
may,
Yeah.
there's a website that might help him that he could do some looking at. It's michiganlegalhelp.org. It's all one word,
Michigan Legal
Help.org.
help.org.
Help.org. Okay.
Okay.
And on our math, we came to $1,611. I know it's $1, but that was the total amount once we added everything up, Your Honor.
Well, you got 1446.11, right?
Yes, Your Honor.
And then you got 18 and 50 in
51.
costs, which is 68, plus 85, which is 185, 135, 153 plus 1446.11 should equal 1599.11.
The mail-in or one of the processing fees was $51, not 50.
All right.
End of the day, Your Honor, it's $1. I'm good.
No, I'm going to change it for you.
It was the filing fee, Your Honor, for 51.
No, I get it. So it's $1,611, right?
Yes, Your Honor.
Yep, that's what I get with that extra $1. You're all set. Have a great day. Thank you.
Thank you, Your Honor.
Bye now.
Bye.
Capital One versus Huey. Thaddeus O. Huey Jr., P504223.
Dylan Clarkey, 88474 here on behalf of plaintiff.
All right. Is Thaddeus Huey here?
He's not checked in on Zoom, Your Honor.
Okay, you can go ahead and proceed, counsel.
Your Honor, I'll rely mostly on the brief and keep this short, but the credit card statements attached to plaintiff's motion specifically required monthly payments, and Mr. Huey defaulted by failing to make the required payments.
Can you speak up or something? I don't know.
Yes,
I'm not catching rip.
Apparently, I need to invest in a new microphone. I apologize for that.
That's all right.
No, in this matter, there's no question that Mr. Huey defaulted in terms of their credit card agreement, and as such, the default provisions of the credit card agreement became applicable. There is no genuine issue of material fact in this matter, and accordingly, plaintiffs entitled to judgment in the amount of $7,520.10, representing damages in the amount of $7,354.40, plus court costs in the amount of $165.70, with interest accruing at the statutory maximum of 13%.
You got 75, 20, 10, is that right?
75, 20, 10, Your Honor.
All right. Plaintiff's motion for summary disposition is granted. There's no genuine issue as to any material fact. So pursuant to MCR 2.116C10, the motion's granted. Judgment will enter 75-20 and 10 cents. You're all set. Submit your judgment. Be good.
Your Honor,
Thank
I
you.
have that proposed judgment already, so it'll be in your box for signature.
Perfect. Great. Okay. Thank you.
Awesome. So just to clarify, the order submitted will be signed?
Yes.
Yes.
All right.
Yes.
Thank you so much. Have a great day, everyone.
Have a good one. Ford Motor Company versus Tilira L. Mosby.
Your Honor, that's a 10:30. The parties just checked in and I just put them into a breakout room.
Do I have Independence Capital versus Pavich?
I do not yet.
Do I have Brook Gorham versus Eastern Account Systems of Connecticut?
I do not yet.
Do I have Amy Lawrence versus Greg's Auto Service? 26005.
Today, this is canceled. He's gonna get a sentencing date. We'll be for sentencing date.
We try to use Wednesdays for Ms. Strong. Are you available Wednesday, May 27th?
I believe so, Your Honor. Let me double check. Yes, I am.
Uh, 11 a.m. Oops, at 10:30. I'm going to ask you some questions. I'm going to ask you, where'd you get it? Whose bagging was this? And I want you to pay on your other stuff. And then we'll figure out what we're going to do. But we'll probably do a drug test that day. I don't expect you to be at zero, because you probably can't get to zero by then, but as a time of probation, you can't use any marijuana. Are you working somewhere?
Yes, sir.
You told me that before, but I forgot where.
Pittsburgh at Summit.
Yeah. What shift?
Third.
So you've been up all night?
I didn't.
Did you work last night?
No,
Okay.
no. I got off. My supervisor, he's just let me get some time off.
And Your Honor, I am owed to Judge Pattison at 11 o'clock. Can I ask one of the deputies to give him a note that I might be a moment late?
Don't say a little late, say she may be late.
A moment late. Thank you, guys.
Pregnant moment late.
I sent an email and I just want to confirm.
That would be Wednesday, May 27th, 2026 at 10. There's courtroom C. I guess this is courtroom C. I'm not sure what it is, but that's what it's called. C, courtroom. All right, Mr. Rose, I will see you on May 27th. Don't get any more trouble. Get your stuff paid off and we'll talk about this probation at that time. Yeah.
You can check with the clerks.
You had allowing another to violate the motor vehicle code set for 331. I'll give you that. I don't think so. I think you got one left. Mhm. All right, go ahead. Yeah, okay. Now, I'm not concerned about Mr. Rhodes, but that is an issue. When you walk right up to the bench, people are concerned that they want to come up and punch me in the nose or, well, you're not.
You gave me 11 million views.
But generally, that's not a good plan. So we'll see. Anyway, he's gonna pay that, and he's famous now, and he's gonna be more famous when he pays his fine. All right, Mr. Rhodes. Okay. Remember the case in Las Vegas where the guy jumped over the bench?
I want to try that. I want permission to try that. I bet I could jump.
When I was young and this courtroom was condemned,
Absolutely.
I have some pictures of me sitting on this bench in a disrespectful manner. The courthouse was, this building was shut down. It was blocked off, and I had me sitting on Judge Oda's bench. I guess I'd see if I could find those. But now it's a bench again. All right, let's talk to Stephanie Smith. This is file 26603FY.
For like a week. I don't know how that would go. Hang on just a second.
I can't.
So I remember they used to. So what do you specifically ask?
I'm asking for just like a week. Continue next week.
I don't want to bring witnesses in.
No, I don't want to do that. I just want to see if I can keep the offer on the table that I have for the CCCD in the morning with Pattison.
If it's okay with the judge, I don't care.
I don't want my plea to change.
Good morning. Are you Stephanie Marie Smith?
Yes, I am.
I'm Judge Middleton. You're charged here with the possession of methamphetamine. That is a felony punishable by up to 10 years imprisonment. You're charged as a second offender, alleging that you previously had a felony driving charge in Indiana. So it's punishable as a second by a 15-year maximum sentence. This is alleged to have occurred in Constantine on January 2nd of 2026.
And Your Honor, in back and forth with my client, I do have a signed waiver of rights and plea. Ms. Smith has indicated and the prosecutor has agreed a request for continuance to next week's in the morning probable cause conference docket. This is our first contact. There are a lot of reports to review. While I do not think that Ms. Smith's position is going to change, she would like the opportunity to fully review all of those reports and have any follow-up questions with me that she needs. And I would like her to have that opportunity so she can move forward knowingly, voluntarily, and understandingly.
Does that mean that
Did you call your lawyer?
I tried, yes, but she's
When?
busy.
We did play phone tag multiple times throughout the week. She left 2 voicemails. I left.
Cases on Judge Patterson. If he's got already a full vote, let's take a look. I tell everybody, call your lawyer.
And she did, Your Honor. We just played phone tag.
Okay, and in defense of the lawyers, they are busy. For example, she's gonna be here with me all day today. So if you tried to call her, you wouldn't be able to get through to her. But she was working over the weekend. She was at the jail on Sunday, which is a real fun place to visit on a Sunday. But I'm concerned about a couple things, Ms. Smith. You've got an unpaid retail fraud charge of $156. You have an unpaid failure to yield ticket with $144.
Okay.
So you have $300 worth of unpaid fines and costs.
I can start paying on those.
I don't know if I reminded you those at the arraignment or not. I don't think I did. Also, if I give you a drug test right now, what will it show?
I'm good.
What?
Are we good?
It will show clean?
Maybe weed. I might have some weed in my system. That's about it.
All right, well, you're not, I'm trying to look if there are any bond conditions in here. Read this affidavit. Has to do with a stolen trailer. During the search, I found a Ziploc bag. So it was hers. 7.9 grams. 0.79. All right. Judge Patterson, he's gonna have a morning like this. Continue. EC to 428. At 8:30.
No, we don't, I mean, to balance out the court, if you want to go 2 weeks, obviously our problem is
Casey didn't want me to do that because it made her.
And
come
Your
back
Honor,
here.
I do believe now that I have offers, things will go very smoothly. We'll walk in with resolutions ready to go.
All right, well, it will, but there's still a lot of cases. I mean, things are going smoothly now. They're just, 30 people we need to address, plus the arraignments. His benefit, he doesn't have arraignments. He doesn't have Tuesday arraignments, so he doesn't get as backed up as I do.
Okay.
All right. 5, 5, 6, 8. your matter is adjourned 1 week. I want you to stop out at the counter regarding those unpaid fines. We're gonna give you a drug test next week.
That's fine.
It will probably still test positive for marijuana, but I don't want to test positive for methamphetamine.
Okay.
I have my suspicions if I was to do a test today, but we'll see. Anyway, this matter's adjourned.
That's it.
And you stop at the counter regarding the unpaid fines.
Thank you. Have a great one.
Any Flowers?
And Your Honor, this is to improper transport. If you would like me to elicit the factual basis, I can. I know that one's a little.
All right, and we used to use this statute a lot. Mr. Marvin, Mr. Robier, what's the citation?
I have to look it up, Your Honor. I apologize. Don't have that one off the top of my head anymore. It is MCL 750.227D.
All right. Mr. Flowers, it's alleged that on April 9th that you had a 25 caliber pistol on your person in a vehicle, and that you had no valid operator's license. If I understand correctly, the prosecutors are going to agree to dismiss both of those charges if you plead to the misdemeanor offense of improper transport of a pistol. That requires the pistol be forfeited. The state police will grind it into small pieces, and as well as the ammunition. Do you understand?
Yes.
It is a misdemeanor. It's punishable by, I believe, up to 93 days in jail and a fine of up to $500. Anybody threaten you to get you to plead to this? Anybody threaten you to get you to plead to this?
I had a neighbor threaten me at one time.
No, but anybody threaten you to plead guilty to this
No.
charge or promise you anything?
Did anyone promise you anything?
No.
You don't have anything in my county, and you don't have anything that shows up on your criminal history, which is probably why Mr. Gabriel was willing to make this plea offer as opposed to the guy with a machete who didn't get such an offer. As far as I can tell, you don't have any criminal record. Is that correct?
Yeah.
Okay. Were you driving in a car? Do you have a 25 caliber pistol in the car with you?
What?
Were you driving in a car with a 25?
I was parked.
All right. Were you in a car?
Yes.
And you had this pistol because a neighbor was threatening you?
I had a neighbor who threatened me and I didn't know what way to take it and I didn't understand the law all the way and I got caught up.
You live in Indiana.
Yes.
But you don't have a carry concealed weapons permit?
No, that's where I messed up.
Well, the law is different in Indiana, but you're in Michigan. All right. Mr. Gary, you right now and find costs to the document?
No, I'm not asking for anything other than that, you know.
Do you have any charges in Indiana? Do you have any cases in Indiana?
No.
Well, how come you don't have a valid license?
Every time I tried to take the test and I failed it.
How'd you get here?
My sister.
Oh, she's back there. Oh, good for you. How long were you in jail before you found it out?
How long were you in jail?
I should probably about a day and a half.
I received the case assignment on the 10th. He contacted me on the 13th.
Something like that.
So I have none. All right, 1 day jail credit, 1 day. Remember these? Gary.
I'm sorry, Judge. What is that?
The pack,
Pack codes?
pack code guy. I'm down on the bench. You can look up the number for cases. Council.
Yeah.
I still have one. Refer to it very often.
Well, I remember when it was just a one binder with warrants. No.
Well, that is called pack code, prosecuting attorney association coordinating council. Signed all the numbers to some of these for 13 years and use that. Anyway, it's a $100 fine, $75 fine, if it's $50 state minimum fee, $150 attorney fee. $250 a bond. Not sure how that came about.
So you're gonna apply your bond, and then you need to go out to the counter to set up a payment plan.
Okay.
Take your paperwork right to the counter when you leave it. Judge will hand it to you, and then you'll be free.
Okay.
Can you pay that $125 a day or any time to pay?
Probably $15 an hour. I think that's close for the clerk office.
Well, I'm gonna give you, can you pay it in 30 days?
Yeah. I know, it takes me time to get back and forth.
Okay. As long as you pay.
Yeah.
That's correct address. 125 by. May 29th. I do remember then, first step off, otherwise it's not going to take any steps, and you can use the instructions inside. Okay.
All set. You're all set.
Okay.
And you sign the waiver of your rights, and then you take those out by the standards.
Two more, record time. Tell Judge Patterson.
We got, Mr. Spence.
Okay. And he is just showing me an email from Community Corrections saying, good evening, I received your voicemail. You're all set for check-in. Our office is in the process of moving to a new physical location.
Oh.
He's asking me.
Yeah,
Yeah, because you and I talked and we're okay.
I'm calling for community corrections. All right, phone. So now my phone doesn't work. Plus I didn't make any corrections like that. 585. That's our number. I don't have any corrections going on. All right, this is Justin Spence. That's you, sir?
Yes, sir.
And I'm sorry, I tried to call community corrections.
Oh, no, okay.
You broke my phone. You broke my phone, so I'm not sure.
I did not touch.
I can't have, call somebody. I did call the jail or something. All right, you're Justin Michael Spence.
Yes, sir.
Mr. Spence, you were charged with possession of methamphetamine and operation.
29. You provided your name,
Henry Murad.
your name.
Martin.
I'm going to ask you to both raise your right hand again. You solemnly swear affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got.
I do.
All right. I got some questions for you. You brought me this guarantee. This is over the lease. Was there not a separate business agreement where you purchased assets?
Yeah, I have the purchase agreement here.
Well, why didn't you give me that? That's what I wanted. Can you hand that to my court officer?
That's the purchase agreement that we did. That's the whole fund.
No, this is the personal guarantee. This is the only agreement you guys entered into?
Yeah, that's when we did it at the lawyer's office on Ford Road, and that's the papers that we did. And that states the other owners' names and
That you're going to pay the lease. Who owns the assets now?
the owner of the building, their names is Ali Saad and.
Do you know this owner, whoever owned the Greg's Auto Clinic when you bought it?
It says it on the paper, on the second page. Greg's Auto Clinic, that's what.
Right.
They own. Yeah, on the second page at the top, it said, Sain Hamadi and some other name, Allah.
Hussein Hamadi and Allah Talib, right?
Yes,
Do you know those guys?
I don't.
Did you know them before you purchased this?
I had no clue about it. Nothing.
How did you get in contact with them to purchase this?
My partner knew that they wanted to sell the business. And so we talked to them, then we found out the building is not theirs. So we went to the owners of the building, we talked to them, and then we did the agreement. And I took over and I changed the name to Greg's Auto Services LLC. They had it as Greg's Auto Clinic at that time.
So everything, the agreement that you entered into, you have no other agreement other than this.
That's the only thing I had.
So who did you contract with, the tenants of Greg's Auto Clinic?
Yeah, Twins. They're called Twins Auto Sales. They have a lot of dealerships. So that's the people that I purchased the business. That's who I'm renting as of today from them. Twins Autos. Ali and Abdullah Saad.
Yeah, but
The other people, Your Honor, they were renting also from Ali and Abdullah Saad, the twins.
and now you're renting direct from the twins.
Yes.
And this is the only agreement you have.
So like did the agreement.
That's why I was confused when I said they took it to a sister shop in Redford, which Twins Auto does have a dealership in Redford, but this other dealership is
Okay,
not.
let's talk about what kind of car repairs that you had to have done.
I had a hole in the put in, and
When was that again? Because I don't want you to think I remember much.
no, I know you have a lot of cases. I put the deposit down for my engine on October 7th of 2024.
And you put it
Yes, that's the end. Because then I.
October 7th of
The
24?
whole engine was 55.89.
Wait a minute. You put a deposit for the engine on October 7th of 24?
Right, and then I didn't get it back until.
Wait a minute, slow down. And then how much was that for again? 55?
55.89.
And that was with the predecessors to this gentleman and his company, right?
I assumed it was the same guy working with him. Like I said, I've never dealt with the same mechanic more than once, ever, throughout this whole process through any shop.
Okay, so I'm gonna need to take my time on this. I'm sorry. Let's start completely over. I apologize. I didn't write. So you gave him 55.89
Was the cost of the whole engine.
on October 7th of 24.
Correct.
And had the work been performed as of then?
No. They took it out to the other shop in Bradford and.
On their receipt, it says completed on.
All right, I just want to know.
Yeah.
What other shop? Was this Greg's auto clinic?
Yes. And then they.
And who was the principal of Greg's Auto Clinic again? Can somebody tell me?
She could.
What do you mean?
Who was the?
Well, that was the predecessor.
Someone named Sam. All he told me was his name was Sam.
Do you know who that was?
I think that's the guy from previous, Hussein Hamadi.
Okay.
understand that ever either.
All right, slow down. I know, but let's just not start. I'm trying to follow this whole thing here. So you gave them money. Was the work completed or not performed when you?
No, they took it out.
Wait, you gotta let me finish. On October 7, 24, you wrote them a check for $55.89, correct?
No, I gave them $3,000. I didn't pay the balance till I picked up the car,
When did you give them $3,000?
October 7th, 2024.
All right, but you still were gonna owe a balance of $25.89, right?
Pick up my car, correct?
All right. And that you think, or so you think at least, that was when Hussein Hamadi and Ayla Talib were running Greg's Auto Clinic, right?
Yes, Your Honor.
Hang on. Just let me get my bearings here. All right. So you drop it off on October 7th of 24.
Correct.
You pay them $3,000 and agreed to pay $55.89.
Correct.
Then what happened? The vehicle was taken where?
To Fast Lane Auto on 8 Mile Road in Redford.
On 8 Mile in Redford. And that's where the work was performed?
Correct.
And do you know if Hamadi and Talib owned that?
That I don't know. That I don't know. The same person I dealt with that took my car there is no longer there, and now there's been supposedly 3 new owners since then at that shop as well.
Do you know for a fact that you gave it to Hussein Hamadi?
The person I talked to told me his name is Sam. That's the first time I'm
Do
hearing.
you think that's who?
Hussein Hamad, that's saying it.
All right, so the work's performed out at Fast Lane Auto on 8 Mile in Redford. And when do you pick up the car?
On the receipt, it says she picked it up on 10/7, one.
That I don't know why they put that, because I know they didn't do an engine the same day. That's.
No, you dropped it
that's
off on
pretty
8/20, and then work completed. On their receipt, it says 10/7 on first.
But they can't be, right? Because I didn't pick it up from Greg's. I picked it up from 8 Mile.
Yeah.
Okay, so wait a minute, slow down. Wait, let me ask you a question. Just wait a second. Wait. So you're telling me you have documentation that indicates they dropped it off on August the 20th, 24?
No, I'm seeing it off of her papers. Can I?
Yeah, I don't.
It says, proposed completion date 8/13/2024. Work completed 8/13/2024 on their work order. Greg's Auto Clinic.
It was completed?
It says completed.
That's just for them to show me all the codes.
Wait a minute.
I paid $241 just for them to.
Wait a minute. Wait a minute. You confusing.
Whole thing's confusing. I could sit down and explain it for.
Well, here's the problem. There's got to be successor liability, and I don't see where there is. I mean, I feel bad for you. I'm just trying to figure this out. But I don't think this company is responsible because they entered into an agreement to lease from the owner of the building the same equipment. And I have to have here as far as let me ask you a couple of questions. Let me just ask you a couple of questions.
Can I say something?
No.
Yes, sir.
Do any of the owners that are there at Greg's Auto Service, were any of those working with Greg's Auto Clinic?
No. The owners of the building, they have over 100 shops. They own a lot of buildings. They run them out to mechanic. Bless you. So they run them out. So these guys that did.
Did you bring your own tools over there?
Of course. So
the tools you didn't purchase from anybody. I mean, you brought them there. You were purchasing the tools
I have,
from Greg's Auto Clinic or the owner?
no, I have my own tools. And I have all the receipts from Snap-on and Matco. So.
All right.
This has nothing to do with them. They took everything, whatever they had, and they left. They said they're moving down to their new location. And then their sister-in-law at the time, she knows her. Her name is Brittany Coquel. She was still working for me, and they didn't even tell her that they're done from.
All right, let's talk about the issue of the engine. What's wrong with the engine?
Nothing now. My car runs like a champ now.
How much did you pay to have it? Tell me what happened when you picked it up from Fast Lane.
And actually, that's what I was just thumbing through and wanted to point out here. The paperwork, and that's what threw me off. They're trying to make it sound like they put 2 engines into my car. And because the first shop didn't replace the turbo, it blew this engine. So now Fastlane gave me a receipt January 27th of 2025 for the second engine that I bought, or that they were putting in, with no, there was no proof of the first engine, which I know they didn't install it all. They take it out to the shop that they said was their sister shop, which it isn't, because now I'm finding out about twins. And I've seen employees go.
When you got the car back.
I do have my car back.
You know, but when did you get your car back?
The second engine they're saying they put in, I have the invoice date for January 27th of 2025. I want to say I didn't get it back until like the end of March.
All right, so when you got the car back the first time, right? You picked it up at Fastlane.
Yes.
What was wrong? Right?
Yes.
What was wrong with the engine?
I made it from Fastlane on the freeway to, I think it was 275 and Sibley exit, and the tow truck had to come and get me. The whole entire engine just died because they didn't put a turbo on that I paid for, and it blew the whole engine, is what they're saying. So then now they're getting a legit receipt for the engine, which I kept asking for the first time. Second time around, I have a legit engine receipt with everything. I think that.
Slow down. Do you know where these guys are now? Greg's Auto Service.
I'm Greg's Auto.
Well, I'm sorry, Greg's
Auto Clinic.
Greg's Auto Clinic.
All I know is they went to Fastlane. That's where their other locations. And that's what
But then when I call Fastlane, and I even have a recording of this, they say that they sold that shop back to them and they're back at Greg's.
Ma'am, here's the problem. If I were you, I'd talk to a lawyer and have the lawyer assist you in trying to locate the predecessor owners. These guys, I cannot in good conscience, there's nothing here that tells me, wait, let me finish. Why does everybody interrupt me, John? I don't understand. I can't in good conscience enter a judgment against these guys. There's no evidence they purchased assets. It's not the same owners. It's not the same people working there. I mean, I feel bad for you. I really do. But I have to follow the law and I don't see it. And if I was you and you want to pursue this, I'd speak to a lawyer and I would have the lawyer help you, at least give you some ideas as to where you might turn.
I figured at the very least, Your Honor, I'd probably walk away with the name, which is probably just gonna be another ghost chase. Unfortunately, I feel like you said it's just gonna be a really hard lesson learned the expensive way.
It's terrible.
I gave you the names of the owners that took your money, and I already feel bad.
No, I know you, and I know you did try to call.
And I brought.
No, this is.
The day I left, I found out my aunt died.
This is an honest.
2 days later, so that's why you didn't hear back from me.
Not a problem.
This is an honest guy here.
I even looked at her car and checked it out for her and added entries, and I'm the one that told her they did not replace the engine. Because if they did replace her engine, it would have had either written marks on it.
Listen, where's the old engine at? Where's the old engine at?
I'm the one that told her to go up to court.
Where's the old engine at?
I never seen anything with the old engine.
By law, they should have, Your Honor, the engine and show it to the customer before they dispute any parts.
Right.
And that's what I showed Miss Amy.
It was a core price on the receipts.
Then if you know I'm honest, why would you write a Google review and put it that you take people to court and all that, and Greg's Auto Shop, and do not take your car there because they changed one word, either Greg's Auto Clinic to Greg's Auto Shop.
That is what they did.
Well, but
you're writing it on my website. It's not me. Sweetheart, I know already you're in pain and whatever these scumbags did to you, it's not right. But you're affecting my good. And I told you, anything you need, I'll help you out. I did an oil change. I did the sparkless cleaning for you.
Wait a minute, wait, please, please, everybody.
Yes, sir.
I made my ruling. I don't know what to tell you. You guys are gonna have to figure it out. There's no way I'm finding him responsible. I'm no cause of action. And you guys can go down the hall and get that. I would consult with the lawyer and have them try to.
Yeah, will any paperwork they give me down?
Yeah, they'll.
Speaks on it, or
Jennifer, give her the personal guarantee that's on there, please.
just the name?
Well, she's gonna give the personal guarantee and she's gonna give you a copy of the judgment, okay?
I appreciate it.
And Judge,
Have a
are you
good
sending
day.
the copy down? Because we did not put that in M file.
John's bringing it down now.
Thank you.
Thanks. Good luck to you, Deb.
Yeah, right.
You too.
Saw your appearance on TMC, by the way.
By the way, Independence Capital Recovery versus John Pavlich, 2503740. Ms. Dillo. You're on Zoom. That's okay. Where is, you ready on this? Do I have, John Pavlich here or not? Jennifer?
Defendant has not shown, Your Honor, but I don't think we can hear Miss Dillo.
I know, Ms. Dillo, I can't hear you. I don't know what's going on. It looks like you're connected, but.
Is that better?
That is better. Your appearance? I need your appearance. Now I can't hear you again. You muted now. I don't know what's going on, Jen. Do you?
No, Judge, I'm not sure. We heard her for a quick second. And no, we can't.
How's that?
Oh,
Is
there
that
we go.
better?
Better.
I'm sorry. Something is wrong with my, apparently my speaker here.
All right, your appearance?
Jennifer Dillo, appearing on behalf of the plaintiff.
Where you been? I thought you ran for Congress or something in another state and were elected. And where you been? I haven't seen you in a long time.
Yes, I've been around.
Okay. All right. Well, listen. Case got dismissed for lack of progress. You filed a motion to reinstate. Do I need to hear argument? No. Motion granted. Order reinstating. You're going to submit an order reinstating the case and indicating that the plaintiff shall send to defendant's last known address a copy of the summons and complaint, and defendant shall have 28 days to answer the summons and complaint. If defendant does not answer the summons and complaint, then you can file a motion or file a default and default judgment. Will you do that for me?
Yes, Your Honor.
So what is going on with you? I'm serious. I used to see you all the time and now you don't come in here anymore.
Well, I left the firm I was at and I went and did some federal practice for a little while. And now I'm back doing more collection work. So I'm back in this realm.
All right. Well, good to see you. Have a great day. Thank you.
Thank you.
All right. Ford Motor Company versus Taliera L. Mosby, 2501052. Good morning, ma'am. Your name?
My name is Taliera Mosby.
Good morning, Mr. Dowski. Your appearance?
Good morning. Robin Stradowski on behalf of Ford Motor Credit Company.
All right. So.
And we have spoken. I believe we've come to a resolution of this.
Okay, go ahead.
I believe Ms. Mosby is willing to withdraw her motion to set aside default. The default judgment will stand as entered. And we will begin, she will begin making payments of $100 a month, beginning May 20th, and by the 20th of each month thereafter.
All right, so you're going to submit then an order that indicates defendant is withdrawing her motion to set aside default judgment with an installment payment order that says she's going to pay $100 per month beginning on May the what?
20th?
20th, and the 20th of every month thereafter. Is that what you want to do, Ms. Mosby?
I wanted to continue on the same payment plan that we discussed previously. I felt that filing the affidavit for a default judgment was premature because, like I stated, I had a financial hardship. I never ignored the request in which you ruled previously. It was my circumstances as to where I fell behind, but I was making partial payments.
She just told me you agreed to a payment plan of $100 per month. Is that true or false?
Right. The payment plan, which was the same one that we initiated. I don't want like it to be a default judgment, meaning that they can change the terms of the amount that's paid. Whatever
we have a misunderstanding then when we talked. I thought that it was an understanding that, and we did have some, our connection was a little bit bad when we were speaking, but I did explain that we did file a response to this and that we, that there was a judgment. We can't re-enter into agreement back and forth when we had already entered into that one. If she would like to go forward with her motion, she could. I believe that she said that she was going to be withdrawing that, but I don't want to misinterpret anything to the court. So if she wanted to continue with her motion, she could do that. But what we could agree to is to set up an installment payment plan on the judgment as entered.
Well, the base. What do you, I mean, I don't know. I'm being told two different things, Ms. Mosby. Do you agree to dismiss your motion to set aside the default judgment and proceed with an installment payment order that calls for you to pay $100 per month? And that's all I need to hear from you right now. Is that what you want to do or not? Starting May 20th.
I want to see if we could if I could have the opportunity to resume my payments with them with dismissing the judgment and continue that plan. I feel like I had showed effort with that.
Wait a minute. Maybe I'm missing something here, Ms. Drudowski. What can you tell me? Was this a conditional dismissal or was it a judgment initially?
It was a conditional dismissal. We attended a pretrial back on September 22nd that she was going to be paying $8,000 at $100 a month, and payments were not made as agreed. We received one payment for $100 in November. Then we had some communication with her in February that she said that she was going to make another payment of $150. We didn't receive that. So in March, we filed an affidavit of default and the judgment was entered.
I see. Okay. And you want to set aside the judgment. It's not a default judgment. It's more of a judgment that's converted because you didn't comply with the terms of conditional dismissal, correct? Is that true, Ms. Mosby?
Well, I was in communication with them.
Well, I know, but you didn't make your payments as you were supposed to. True or false?
Yes, I fell behind, but I made partial payments. That's true.
All right. Well, that isn't good enough. So they're entitled to the judgment. And now the question is, how much are you going to be able to pay? And that's up to you. If you two want me to conduct an installment, a creditor's exam now or an installment payment order hearing, I'll be happy to do that.
Okay. So when I'm making payments in November and I'm emailing the attorney Debbie in response to that, and then I'm making a payment in December, and I call to make an arrangement, and then they send an affidavit if I make a payment on the date that was outlined, they could just send an affidavit to dismiss me communicating with them and showing good faith on that payment arrangement. I owe $250 out of $600.
But you're asking, is there a question or you didn't make the payments as agreed upon, so they're entitled to the judgment.
So if someone has a financial hardship and I express that,
That's what you agreed to. I didn't agree to it. You agreed to it when you agreed to the terms of the conditional dismissal, and you breached the terms of the conditional dismissal, so they're entitled to a judgment. This isn't, it didn't have to say we have to have a hearing and the court has to determine that the defendant could have paid and didn't. It's just, you didn't pay, so they're entitled to a judgment. Now the question is, going forward, how do they collect on the judgment? They can garnish wages, they can garnish bank accounts, they can garnish tax returns, they can execute on property. If you enter into an installment payment order, they're not prohibited from doing any of those things, but they are prohibited from garnishing wages. Some plaintiffs' counsels don't do that. If you're paying in accordance with the installment payment terms, they don't seek to collect on tax returns or garnish bank accounts, but that doesn't mean that they won't, or they have to agree to it, or that they should agree to it. So I don't know what else I can do for you. I'm gonna deny your motion to set aside the judgment because you didn't comply with the terms of the judgment.
Okay.
Now, what do you want to do?
I'll make the $100 payments per month, like I stated with an attorney.
Is that, you want to submit a separate order for that, Ms. Stradowski?
Yes, we can.
Set forth an order denying motion to set aside judgment.
Yes.
And then you can do on a separate document installment payment order that calls for her to pay $100 per month commencing on May 20th.
Yes, we will do that.
Now, if you don't do that, then they're going to move to set aside the installment payment order, and they might go so far as having creditors exam and make you bring in your car titles, your bonds, your stocks, your ownership of real estate, where you work, your tax returns, etc. And then they can start garnishing. So you want to make sure you stay with those payment plans, okay?
Yep, okay.
All right. Anything else?
Nothing further from us.
Anything else, Sam? Ms. Mosby?
No, you
Good
made
luck.
the ruling is fine. I'll just have to do what I need to do. That's fine. Thank you.
Have a good day.
All right,
Yep.
thank you. Have a good day.
Who is? I don't have a file.
No, Oakland County, we were at problems with Oakland County, but I think we got it.
Yes, they're in the breakout room
She's got
together,
file.
and then Detective Merker is here already in the waiting room for it.
Jennifer,
Yes, Your Honor.
did we send out a notice regarding why this claim should not be dismissed
Yes.
for
On
failure?
the
to-
Gorham.
Yeah,
Yep. Yeah, because she was on the docket previously. You had asked her to bring back documents with her to the next hearing, I believe. And when you entered the default, because you were asking her about the amount of her claim.
I'm
And then-
just, so you've sent out this notice. I wrote, nobody appeared. Sent out notice regarding why case should not be dismissed for no progress. So I'm calling this Brooke Gorham versus Eastern Account Systems of Connecticut, Inc. I think it's Connecticut. It's CT Inc. 2504915. Neither party appeared,
That is correct, Your Honor.
and you sent out the notice for no progress, or a notice to
Yes.
appear why.
Yep, the notice
Is
went
there-
out on April 7th indicating hearing on no progress, notice of intent to dismiss issued. So we did send along
Case
with it a
dismissed
notice.
for no progress. Nobody showed up. It was scheduled for 10. It's now 11. Is that it for me this morning, or?
You have that arraignment.
No, other than
But
that,
other than
though?
that, yes, the civil is done.
Okay, and we're just waiting for Mr. Shemke?
Yes.
Yes.
Is the defendant in the Zoom?
Yes. Yes, they're in a breakout room together, and then Detective Merker is in the waiting room ready to go too.
Okay, so right now Shemke's in with the defendant.
That's correct.
All right, good enough. Will you tell me when he's back here? Jim? All right, I'll be back as soon as they're ready. Thanks. Seven one. So 25R713371. Sir, your name?
So Russell Conklin.
I gotta get closer to that device. Keep your voice up.
Russell Conklin.
Keep your voice up, sir. I gotta pick you up on the recording device here.
I'm having medical issues. I can't talk. So I don't know what you want me to do. I'm medically unable to talk louder than this right now.
Hang on, move over to your right ever so. There you go. Tell me your name nice and loud.
Philip Russell Conklin.
Okay, Mr. Shemke.
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client. This time we consent to the matter being heard via Zoom. As the arraignment, we waive formal reading. My client stands mute. I have reviewed the charges and the maximum penalties on both cases. We are prepared to proceed.
All right. Lieutenant, your name, please.
Detective Lieutenant Steve Mercury, Rockwood, please.
All right, so let me go back and take a look at these. You've got a felonious assault with a fourth offense notice. Felonious assault is a 4-year, but you've got a habitual fourth. And if you're convicted of something that carries with it 5 years or more, which you're not going to be, you could get life. But in this case, if you're convicted of something that carries with it less than 5 years, you could get 15. You understand that, sir? Nice and loud for me.
Yes, sir.
And then that's on 25R713371. And then on the other file, this is 26R705091. We have assault with intent to do great bodily harm, less than murder upon a Carly Skidmore. And we also have a domestic violence offense with her. There's a fourth habitual offense notice. So if you're convicted of that charge of assault with intent to do great bodily harm or anything that carries with it 5 years or more, you could get life. The domestic violence stands alone. That's a 93-day misdemeanor on that one. Do you understand that?
Yes, sir.
I don't know why I'm not getting a good, strong. Can you keep your voice up, please?
Judge, he's doing his best. He has an ailment and it was very difficult to hear, but he did believe that he understood and he said, yes, he understands, Judge.
Okay. Is that true, sir? You understand everything?
Yes, sir.
Now, I'm going to go ahead and tell you your rights. You have the right to remain silent on all of these. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You have the right to be represented by a lawyer today. You have the right to be represented by a lawyer at all subsequent court proceedings. And if you ever choose to submit to questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
You have the right to a probable cause conference on these. You have the right to a preliminary examination on these. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the probable cause conference, if it's not resolved, it will then proceed to a preliminary examination. At the preliminary exam, as to the felony counts, the people have to show that the crimes were committed and that you were the one who probably committed the crimes. If they prove that, you'll be bound over for further proceedings to the Wayne County Circuit Court. If they fail to prove that, then the case would be dismissed and you would be discharged. Do you understand that?
Yes, sir.
All right, so I'm going to give you the probable cause conference dates, and then we're going to address bond. You're going to be in front of Judge Hessen. Heather, what do you have for me?
These ones I believe will actually be yours, Judge McNally. It'll be May 5th at 9:15 and then May 12th at 10:30.
Okay, are you sure about that? I'm fine if that's the case. I didn't.
That is what I was told. Yeah.
So preliminary probable cause conference, May 5th at 9:15, preliminary exam, May 12th at 10:15 or 10:30, did you say?
10:30.
All right, so that's when I'm going to set both of these. Now, just give me 1 second, everybody. So May 12th at 10:30 will be the preliminary exam on both of these files, and then May 5th at 9:15 will be the PCC. All right. He has multiple warrants, 1, 2, 4, 5, 6, 7. It looks like, Mr. Shemke, what would you like to say regarding bond?
Your Honor, he's been in custody for 27 days approximately on a possession charge. Next court date's coming up next week. He's 38 years old, lives in Warren with his girlfriend, and was working at a tree service location in Romeo. Judge, with the other holds, I just want to make sure that whatever positions he is, he's getting credit for the time that he's served. I find that any monetary amount would be unlikely for him to be able to post, especially with other holds. Thank you. Nothing further.
Detective, can you tell me a little bit? These are both out of Rockwood. Tell me a little bit about these cases, will you please?
Your Honor, the one case involves a strangulation. The felonious assault was regards to a knife that was pulled on the victim, and then the great bodily harm in the DV is it's a strangulation case. He no longer lives at that residence, or the victim no longer lives there either.
I don't know if I want you to put it on there. Has he been printed on either one of these? How are we going to get him printed?
No, he has not, Your Honor.
How are we going to get him printed?
I don't know. He's in custody, and I believe it's Oakland County now. I guess we could do it if they bring him for the PCC or the exam.
You know, I'm getting a little concerned with these guys being in custody, everything by Zoom. They're not driving people around anymore. We need to get the prints. If he somehow waives at the next hearing, how are we going to get the prints to send downtown? So would you call Oakland County and see if some arrangements can be made before the PCC, please? Lieutenant?
Yes, I'll call.
And I can address it then. You got multiple warrants, sir.
Mm-hmm. Yes, I do.
That never bodes well.
Um,
I'm setting 50,000, 10% on both of these cases, 50,000, 10%. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. You're not to have any contact with the victim, Carly Skidmore. No contact with prosecution witnesses. No alcohol, marijuana, or illegal drugs. No firearms or dangerous weapons. You're required to obtain a tether. You're not to be within 2 miles of the victim, their residence, or place of employment, not to be released until fitted with a GPS tether. No contact with the victims. Again, Carly Skidmore on the 26R705091. That's the victim on that case. And on the other case, we have the victim as being Joanna Lopez. So no contact with her either. No firearms, no alcohol, marijuana, or illegal drugs. Not to be within 2 miles of the victims, their residence or place of employment. No contact with prosecution witnesses. no contact with the victims. You cannot leave the state, cannot violate a law. You must appear in court as directed. Those are your court dates, May the 5th at 9:15. Any questions?
Versus, is it Lagardi?
Yes. Thank you, Robert. Stephen Patel, on behalf of the people. Good afternoon, Your Honor. We have voucher P 80177 on behalf of Mr. Lagardi. May I state your name for the record? Stephen Lagardi.
All right, I understand we've got a plea worked out.
That is correct. The date time for bench trial, depending when.
Ms. Lagardi, go ahead and have a seat.
We did reach a resolution. My understanding of the plea is my client would be pleading guilty to the original count of domestic violence that would be deferred under 769(4)(a) with a 6-month probationary term. And then the people did agree at the end of that probationary term that my client's firearm that was taken as part of her arrest would be returned. Your Honor, the notification of legal counsel is correct and accurate. Judge, we know that you make the call on sentencing. We're hoping here that you'll sentence immediately. We have our victim here.
Okay. Okay.
Secondly, Judge, turns out sentencing, at least the first meeting with probation, first month to reporting, and then probation into a determine whether she needs additional.
Okay. Ms. Belcher, you okay with an immediate sentencing, or do you think we need to do a PSI?
It would be okay with immediate sentencing, and that would allow her to have that deferral enter faster so that she could obtain employment.
Okay. All right. Ms. Lagardi, you understand your rights and options? You understand your rights and options. You understand the possible penalty for the charge. And understanding all of this, are you pleading guilty to the charge? Are you doing so freely and voluntarily? Ms. Belcher, would you voir dire to get me my facts? November 25 is the offense date.
Yes. And that's November 25th, 2025, were you at or near a location of 38590 Abilene, A-B-I-L-E and E Street in the city of Rollins, County of Wayne? Yes. Ma'am, and is it true at that location that you would resided with an individual by the name of Leah, last name of Hay? Yes. Okay, and you guys were roommates? Yes. And is it true, ma'am, that on that day that you guys got into a verbal altercation? Yes. And at some point during that verbal altercation, is it true that you put your hands on Miss McKay without her permission? Yes. Is that so?
So the court, what should I know before I sentence Ms. Belcher?
Would you like to review?
You don't have to jump up. I'm sorry, say that again.
Would you like to read the victim's impact statement before?
I don't care either way. Victim, where's victim at? Victim?
Sure. Her name is Leah McKay. She's here.
Ms. McKay, is there anything you want me to know before I sentence?
No, I can tell you that the defendant and the complaining witness were best friends for a long time. They put together. They had a great friendship, and they still like one another. So maybe you could help me.
I feel like there was a misunderstanding, and it could have been communicated a little bit better. Well, we don't have to be here. Boundaries were crossed that didn't need to be crossed. I'm heartbroken right now talking to you. I don't want to ruin her life. I don't want her to have to deal with this for the rest of her. She has 2 children that I look at like my nieces. I love Miss Lagardi. I hate that we here. So please, like, I don't want you to be super hard on it. Like, and that's just me as a friend and sister, dog. I want to see her win. I want to see her do good in life. I don't want to see her down bad or in a bad position. We always been there for each other. I'm talking about drop up a call. And I will always be there for her. And I just want you to know that. Like, there's no ill.
No, I appreciate it.
No ill will towards her. I I could have made a bad decision at night too. I chose not to, and that's why we're here. Like, I love you more at the end of the day. That's what I have to say.
Thank you. You're welcome.
Your Honor, Ms. Lagardi was arrested and charged with that has been pending on her record for quite some time. As the court may recall, I'm not the original attorney.
Yeah.
She did have to counsel for whatever reason with her original attorney. We did have some delays with the trial date that were to me and my surgery. One we attributed to the people because we converted the trial date to a final pre-trial. Ms. Lagardi did accept responsibility for her actions. As you've heard, these two individuals were best friends. However, because of the amount of time that this case has been pending, Ms. Lagardi has lost her job. She has not been able to get employment.
Where was she working?
I was working for Evolution. I was the game present for like FanDuel.
Okay. Yeah. Okay.
As you've heard, she has 2 small children that she's responsible for. She's now 3 months behind on her rent. She's in a very bad spot financially. We would ask that Your Honor take that into consideration. She did accept responsibility in this matter for her actions. This was something that probably escalated, that should have never escalated on both sides. And if they work this out in the future going forward, hopefully they never have this issue again. What I would like to see happen is that the court could waive any of the fines and costs so that Ms. Lagardi doesn't fall any further.
Shocked. I'm shocked, I say.
You know me too well, Judge.
Go ahead.
But as the people had indicated, they wanted Ms. Lagardi to report for at least one of those probationary visits. She has not had any bond violations. She has no criminal history. I don't know how much supervision she really needs, Your Honor, but she's willing to comply and not break any laws for 6 months. But I would ask after that first visit, if there's no issues, that you convert it to non-reporting probation.
Where you living?
She, if I may.
Yeah, that's all right.
Mother's address on the advice and rights form. She does have a separate address just due to the relationship between these two individuals right now. If it's okay, you can tell the court off the record.
Geographically. I don't need an address. Okay. All right. And you're not working now?
I've been doing like it's her.
Okay. So the tangent alert. Okay, this got nothing to do with sentencing. Before you get out of my building, go down and talk to Avery Taylor, and if he's at lunch, get a card so you can call him and ask him about jobs in the area. All right. Tissue boy.
We're gonna have that to.
You got one right in front of you. All right. Is there anything you want me to consider before I sentence you?
Yeah, I think it was, well, I just want the court to know that I'm truly sorry for this time. I'm so embarrassed. My 2 little girls mean everything to me. The only thing I feel like I'm really lacking is I can't pay these bills. Like, I can't catch up since this. I am taking them to Florida on Thursday. We'll be gone for 4 days. We deserve to laugh. So I just want to say thank you for your time.
Okay. Miss McKay. She's under my thumb. I can make her do some things. I want you to do some things. You guys willing to go to a couple sessions of counseling together?
It's supposed to be on. We can sit down and have a conversation.
Does she need anger management? All right, here's what I'm going to sentence you to do then. Miss McKay, come on up here. Get her, Joe. Come on, all the way. Okay. You guys spend my $25 gift card, spread it out over as much time as you can, and have some sessions, just you two girls. Find somebody for the kids, okay? You're gonna, what's that? Say, I didn't hear you.
Sorry, I need someone there, like, immediately.
You okay with that? Who's it gonna be?
Whoever, I don't care.
Who you want? Who's gonna have the kids? Okay, yeah. You got daycare. Okay, all right. So the three of you women are gonna, and like I said, I don't want you to go blow my $25 all at once.
I'll give her the card.
All right. But you guys, and you're gonna give me a report. We met on this day. We spoke for this long. You don't have to give me details. And when we met on this day, I want you to give me a report. You're court ordered to do that. She's gonna be raise your right hand. You swear affirm to be a temporary probation officer for the 34th District Court?
Yeah.
Okay, there you go. She's my probation officer. She's gonna keep you on track on this. Okay? Can we do this? If you're gonna come back too. We're gonna actually sentence you to come back for a 6-month review. You'll set it up. Ms. Belch will set it up. And the two of you, you can bring mom too. Love to meet mom. The two of you are gonna stand in front of me at the end of 6 months and you're gonna give me a report on what the relationship is. And then I'll decide whether or not I'm gonna dismiss this. All right? So I wanna see a real strong effort from both of you to put this as far behind you as the East is from the West. Then it won't have to affect her life because we'll dismiss it at the end of 6 months. You can buy her the t-shirt that says been there, done that, and it's done. Okay? We good?
We're good.
I was going to order 4 days on the work program for you, but these tears have just weakened me. I'm getting ready to noodle down.
You don't deserve that. Look at her.
Okay.
Be on the side of no road.
You good?
We're good.
You made my day. This is what grace looks like.
You.
You're welcome. Go away before I start crying.
Save this middle contact because we just left it.
I think we probably should. All right. Enjoy my exorbitant gift card. Good day, all. Oh, for the record, no costs. I'm looking forward to that report, Ms. Belcher. Thank you. This is yours. Thank you, gentlemen. I don't know how you're gonna write that up. That's your problem. All you gotta do is stay out of trouble, 6-month review.
Let me just ask you this, okay, I'll do that, but the review is not set. So do I?
No, Ms. Belcher will contact us in 6 months and set up a review.
Do you want me to set it up ahead of time? I can go down there and set it up.
It's actually gonna have to be scheduled with Heather.
Yeah.
I can email Heather and I'll include Mohammed.
Fine.
Okay.
Judge, I didn't address it. She has permission to leave the state though.
Oh, absolutely.
Okay, thank you.
Yeah.
Okay.
Yeah, I'll email her and we'll get a date.
So I will leave. Hey, hi.
I didn't. I make nothing to make it super.
And I gotta wait. I gotta wait. I gotta wait because Marion's still got swept.
You can be here for a while.
You got it. You know, this traffic on or wash or like.
Can't turn it.
No, you got it because we got 3 o'clock is good enough. And it's like a mock trial thing.
Glad you said something because I'm like, I don't do that it's out there. I think I'll be here. Oh, so. Oh, good. So good to see you.
Anybody has a personality.
Bye, Dr.
Have a great kid. Great day.
So.
What? No
You have
contact.
the personality of adolescent.
Which
is a compliment.
No contact listed.
Yeah.
And then,
Yellow. It's your boss. Who the hell are you calling? She's watching me on YouTube as I'm talking to her and she says, who's that? You need a nap? Oh, we can shut this down. Oh shit, then I gotta have Fred come up and set up a Zoom thing. Cause, yeah, but I don't have cameras or anything. My computer doesn't have a camera. I don't know.
Let's go in there. I'm gonna, you tell her.
Just call Fred, cause I gotta get something to eat. And then Mary Ann's out here bothering me. Oh, I can do it from out here. Oh, maybe that's how I did it. Okay, that'll work. See ya. So you can shut the TV off.
All right, so let's go in here and maybe Heather can.
See you after lunch, Joe.
I can see,
See them.
that's not very nice.